USA, people find themselves in court.
Okay. Ms. Mohammed, are the people ready to go?
Yes.
All right. Let's go on the record in the matter of Henry Hearns, 25116-1. And appearance for the people, please.
Good afternoon, Your Honor. Mohammed on behalf of the people. Morning. Good afternoon, Your Honor. Your Honor, John Wolfbot, P 30758 on behalf of Mr. Hearns. Mr. Hearns, please put your name on the record.
Good afternoon, Your Honor. Henry Hearns.
All right, thank you. And so today's the date scheduled for a probation violation. Your client is on probation for 2 counts of domestic violence. And there's an allegation that there was third-party contact with the victim on January 28th.
Yes, Your Honor. Hold on. I understand, Your Honor. And Your Honor, I did receive the information when this was placed on the docket. I reviewed the documentation that has been presented. I've shown Mr. Henry the allegations as well as a lengthy note from, I believe it's an individual by the name of Grace, who is the victim's daughter.
Okay.
And explained to him what the purpose of the probation violation hearing was, and what the allegations are. With that said, Mr. Hearns would plead guilty to the violation.
Okay.
Is that correct, sir? Yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And you heard the allegations, correct? Right.
Yes, Your Honor.
And you understand the possible penalty as a result of your plea, whether in this court or any other court. Do you understand that?
Yes, Your Honor.
And you understand in this matter that the recommendation is for probation to be revoked. Case closed without improvement, $50 probation violation fee, maximum incarceration. Do you understand that's the recommendation?
Do you understand that? Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
All right. And counsel, if you can please voir dire your client.
Mr. Hearns, you're placed on probation to this court. Is that correct? Yes. And as part of those terms and conditions of probation, you're not to have any contact, either direct or indirectly, with your with the victim in this matter, which is your wife. Is that correct?
Yes.
And you're going through divorce proceedings at this point in time?
Yes.
Okay. And did you on January 28th of 2026 text Miss
Gracie Grace.
Okay. Did you text Grace Edie? Is that her name?
Yes.
With some information. Is that correct?
Yes.
And that text was sent, and you knew you weren't supposed to do it, correct?
Yes.
Why did you do it?
Well, on the 28th, my daughter had a car accident.
Well, hold on. We'll go into that in just one moment, counsel.
Okay. Right. So you texted her, knowing you weren't supposed to. Is that correct?
Yes.
Violation of the court's orders, correct?
Yes.
That says.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the violation. And sir, why did you send that message?
On the 28th, I was on the phone with my daughter. She was on her way home. She was on her way home from school from a transportation company. Somebody rear-ended her, and she wound up busting her head open and messing her lower back up in the back of her neck. So I'm hearing all this on the phone. She's screaming and hollering, "Dad, Dad, Dad, help me, Dad." So the phone dropped. So I'm still hearing her. And the guy that was driving picked up the phone. I said, "Where's my daughter?" He said, "I'm cleaning the blood out of her eyes. She can't see right now, Mr. Hearns. Just hold on one second." I said, "What happened? What happened?" So I'm panicking, Your Honor. I'm panicking. I don't know who to call. I don't know what to do. I don't have no car. I don't have nothing. Right? So I'm trying to figure out, okay, is my daughter okay? Is she conscious? Okay. Did you call the ambulance? Yes, everything was done. So the fire truck got there before the ambulance. I'm still on the phone with her, Your Honor. He gave her back the phone. He has the phone up to her. So she's crying hysterically. I say, Gracie, her name's Gracie as well. My daughter's name is Gracie. I said, Gracie, are you okay? Are you okay? Dad, I need you, Dad, I need you. And that's one of the worst feelings a parent could ever hear. So I don't know what to do, Your Honor. I don't have a car. I can't go anywhere. I'm calling everybody. It's doing the work hours. I called everybody. So in my panic, I said, well, let me text Gracie, because she always had a rapport with my daughter in the past. So I said, let me text and see if anybody could go up there, because she's by herself. I said, the guy got back on the phone and they call him Mr. D. I said, Mr. D, is my daughter okay? Is she okay? Well, the ambulance is looking at her right now. I said, well, what's going on? I need to know where you guys are exactly. And he said, we're on 23 miles and something. Our home is 5 minutes from the hospital. So
Wait a minute. I'm sorry. What city was this in?
it was in Wyandotte. As soon as she got out of
So what's 23 mile?
That's what he said, 23 miles and something. I don't know why he said 23, because she's right. She was like, she called me as soon as they got in the car. So maybe 5 minutes afterwards, I hear a bam, a loud. And I'm panicking, Your Honor. I'm just totally in panic mode. Don't know what to do. I called everybody. My buddy, my godbrother that lives there with me, he's at work. Everybody else is at work because it's at like 3:15 and everybody gets off at 5. So I don't know what to do. I'm panicking. It wasn't no disrespect. I didn't mean anything by it. I wasn't trying to connect.
Hold on.
I just
Pause. Is Constance Hearn's daughter a person that you are prohibited from having contact with?
Yes, Your Honor.
When you contacted Miss Hearn's daughter, did you reference Constance at all?
Yes, Your Honor. I said,
Your Honor, if I may, the text message that's complained about states, can you ask Mom if she can go to Beaumont Hospital in Wyandotte? A car just ran into them and she is injured. Gracie, his 10-year-old daughter, is hurt really bad. That, it appears, was what was text.
yeah.
Sir. Well, there's not a Beaumont Hospital in Wyandotte.
I was panicking, Your Honor. I wasn't thinking.
And second of all, sir, you have a number of family members from what I recall. There was no need to contact any of the individuals that you were ordered not to contact.
They were at work, Your Honor. Everybody was at work. Everybody I called was at work. And I even called the neighbor in Wyandotte. I called him. He was at work. So I'm trying to call anybody I can think that was in Wyandotte that can get to her. Because I knew I wasn't going to get to her until about at least an hour. Because I'm like 50 minutes away from there. And still, I don't even have a ride set up yet. So I knew it was going to be at least an hour before I could get to her. And I panicked. I didn't mean anything by it. Didn't mean no disrespect. I understood, Your Honor. And then once I got there and I calmed down and I thought, I was like, hey, I wasn't supposed to do that. And I thought about it then. But right at the moment, I was thinking about my daughter, Your Honor. Just somebody being there with her. That's all that mattered to me at that moment, was somebody being there with Gracie. Because I didn't know what condition she was in at the end of the day.
So how does your daughter get back and forth to school?
Transportation.
From Wyandotte to
Clinton Township.
Counsel, do you have any objection if this court reads this communication that's in the file?
Your Honor, I do, only
Okay.
because
I have not read it.
no, I know, Your Honor, and I have read that and I have been provided with that. And the communication is clear. There's no doubt, and he's admitted to it, that he texted Gracie for the reasons he did. He's admitted to the violation. My objection is to all of this other is that it's lengthy. It alleges a lot of things that are not before this court, whether they're true or not. And when I showed them to Mr. Hearns, he is contesting, or at least this is,
Okay,
so
Um,
I do have some objections, only because it really has nothing to do with the violation.
okay. You have your phone with you, sir?
Yes, Your Honor.
Great. Pull up January 28th.
We need to pull it up where you like this person.
Pull up your call log. Pull up your call log for January 28th.
I can go back.
Yeah.
Okay. Okay, here's 28th, Your Honor.
Okay, great. Any objection to this court reviewing your client's phone for January 28th call log?
Absolutely not.
Guess not, Your Honor.
Okay, you can show it to Mr. Mohammed so he can see it. Okay, so January 28th. What time did you got a call from the transportation person at 3:15, correct?
I was on the phone with my daughter
Or sorry, 3:15.
around 3:15-ish. That's what she called.
All right. So what is your daughter's name saved as in the phone?
Grace Booters.
Okay. That shows 303. Who's Alex Newjoint?
That's my godbrother I stay with.
Who's James Bro?
That's one of my brothers I call.
Divergent Transportation is who drives your daughter.
That's when Mr. D called me,
Okay, then James Bro called you at 3:23.
because we was trying to set up a ride to get to her.
Okay, so what resulted from that phone call?
He couldn't do anything at the moment because he was at work.
Who's May May?
That's my sister Mary.
Who's the 313-998-6739 number?
Probably a spam call.
All right, then probation officer Shine. Frog Lip Potato Chip?
That's my niece. I call her that. Her name is Iris, but I called Mrs. Shine to let her know that I'm going to be going to pick up my daughter just in case they see that I'm out. I'm heading to the hospital. That I called her.
Okay, and then Frog Lip Potato Chip called you back.
Yes, she was trying to set up a ride to go get Grace, but she stays out there with me by Clinton Township. She stays in Sterling.
Okay, so did she end up getting a ride?
No, ma'am.
Farisi Poo.
That's my other niece, Ferris.
All right, then you called James Bro back.
Yeah, he's still trying to set something up.
Then you called Grace back. Alex Newjoint called you back.
He was trying to get off his construction and come and pick me up, which he later on he did. He came and got me, and we went there.
Okay, and then what time was that?
Maybe a little hour and a half, I think, later.
Okay. Then Grace Booters, you called her twice at 4:27. And then Billy, new number.
That's my brother.
Okay. Then James Bro again at 4:30. Grace Booters, missed call at 4:32. Katrina, who's Katrina?
One of my other friends, I was trying to get her to get out there as well.
Okay. And then Grace Booters, again at 4:40, you called her. Carla, transportation supervisor, called you.
Yes, ma'am.
Who's Black Mama?
That's my sister Louise.
Who's Steve's mom?
Oh, that's Melinda. Remember my friend that was here in the courtroom?
Why? I don't know. Just so you know, Grace Booters is calling you. I'm declining the call.
Phone got.
James Bro called in, called back. May. So what time did you contact Miss Hearns's daughter, Grace?
Your Honor, according to the document, it's dated approximately 3:14 and 3:15. In the back of the.
So, sir, your message to Miss Hearn's daughter, Grace, which you don't have stored in your phone. So is that a new number she has?
Excuse me.
Is that a new number that Grace has? Miss Hearn's daughter, Grace?
No, that's the number that I've always had.
You don't have her stored in your phone?
Yes, it's under Grace's wife's daughter.
Your Honor, but he texted her, didn't call her.
No, I didn't call.
I understand.
Well, his call would only show those that he
Right.
called.
I'm very aware of that.
Okay,
What I'm also very aware of is that on the text message, it doesn't have anything on here that says the name. That's why it looks like it's just a number that you didn't have stored. Can you ask mom if she can go to Beaumont Hospital and why not?
Yes, sir. Yes, Your Honor.
Well, sir, there's you're right. Did you have somebody, did you attempt to have somebody reach out to Miss Hearns? But what was going to happen when you got to the hospital and she was at the hospital?
Well, I was going to call my daughter's Grace's phone and let her know I was 15 minutes away. And when I was 15 minutes away, she was to leave and I was to come in.
Where's that information at?
I didn't want to keep texting. I was just going to call my daughter Grace.
Why didn't you want to keep texting?
Because I just didn't want to violate Your Honor any more than what I did. Because I was already panicking. Once I made the call, once everything was settled down, I was like, you know what? If they get there, fine. I'll call Gracie, which I did 15 minutes before I got there. No one was there. And my friend Melinda wound up getting there before I did. So she got there about 15 minutes before I got there. But it wasn't to have no contact. That was never the intent. Even if Gracie, her daughter, would have went, that would have been fine. Just somebody that Gracie recognized. That's all I wanted. Even if it was the neighbor, somebody she recognized so she could feel safe.
Well, sir, here's the thing, right? Constance Hearns is not your daughter's mother, correct?
No, Your Honor.
And you and Constance are in the process of a divorce.
Yes, Your Honor.
And when did your daughter move out of the home out of Constance's home?
About 6 months now, Your Honor.
Right. And does your daughter and Constance have any contact within the 6 months?
No, Your Honor.
No. So you thought it was appropriate for Grace to have her mom go to the hospital. If you wanted somebody to be with your daughter, Grace, right? You testified a little bit ago that Miss Hearns' daughter, Grace, and your daughter, Grace, have a good relationship, right?
Say that one more time, Your Honor.
The two Graces you testified both had a good relationship, correct?
Yes, from last day we're in contact with each other.
Okay. So when were they last in contact with each other?
Year and a half, maybe.
Okay. So why didn't you just have Grace go sit with Grace?
Well, that's what I
No. Because you specifically said, can you ask mom if she can go to Beaumont Hospital in Wyandotte? A car just ran into them and she is injured. Grace is hurt really bad. Well, first of all, nothing in there about can you or your mom go there? Or can you go there? Nothing. Your first comment was for Constance to be asked to go there.
You're correct, Your Honor. But what I was saying in that statement was, it doesn't matter who goes, rather she goes, Grace goes, the neighbor goes. I just wanted somebody with my daughter. And that's the honest to God's truth. It didn't matter to me. I was just panicking because I heard my daughter screaming and yelling and howling. And I just wanted to make sure she was okay. Mr. D went to the hospital himself, so he couldn't even sit with her. So she was by herself.
What about the transportation supervisor person?
No, she was somewhere else. She called me on the way there. You know, she was on another job or whatever.
But she was on her way to the hospital.
No.
All right, Mr. Mohammed, do you have any questions or any input as it relates to the recommendation in this matter?
No, I will defer to the court's discretion.
Does Ms. Hearns want to be heard?
Yes.
Okay, ma'am, I'm going to have you come. You can stand over next to Mr. Mohammed if you'd like. Okay, Mr. Hearns, I'm going to have you step back, please.
Okay.
Go back, thank you. Okay, and your name for the record, please.
Constance Hearns.
Okay. May you please raise your right hand. You solemnly swear or from the testimony about to this matter be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Okay. And what would you like the court to know regarding the recommendation in this instance regarding the third party contact?
Well, first and foremost, my concern is that there's plenty of people that could have been contacted. My daughter hadn't had any contact with his daughter in a very long time. So him contacting my daughter was a direct line for him to contact me. And for it to say Beaumont and Wyandotte when there's not a Beaumont and Wyandotte, that leaves open Pandora's box for me to contact him to try to find out where Grace is at. I was not going for that as well. And for me, he's already been served with a PPO. So for me to even go there to even have contact with Grace or to have contact with him, whether I went there or not, would have been in violation of the PPO. So as soon as I got home from work and my daughter told me what had happened, she showed me the text. I contacted his probation officer, left a message. I contacted Wyandotte Police Department and I told them what was going on, asked them what should I do because he was already served with the PPO. They told me to make a police report, they'd send an officer over. So they sent over 2 officers. I showed them my daughter showed the phone. And they took all the information. And then when his PO contacted me, she asked me to write a statement. And she also asked my daughter to write a statement. My daughter came up here and she also spoke with Detective Sabo, and he had her write a statement as well. So my concern was, if my child is in an accident, I'm going to know exactly what hospital my child's going to. I'm Henry Ford or it's Beaumont and where it's going and who am I contacting. So to say Beaumont and Wyandotte, that was alarming to me. The questions that I was asked even today was, did I know for sure if Grace was okay or if she was even in the hospital? And I did not know because I did not contact anybody. Because then again, it would be in violation. So I did not know.
Okay.
And it just seems to be, and I did add other things into my statement because it seems to be an occurring situation. Just as him getting his belongings, having his friend Alex coming to get his stuff. He was given clear instructions from our divorce lawyer to his lawyer. They were to come and get their stuff and leave. And that did not happen. They came, as soon as they pulled up with the U-Haul, they came right to the door. The stuff was outside. They came to the door asking for me. Henry was on the phone with the other gentleman the whole time they're getting their stuff. And the gentleman, it's recorded on my Ring camera, where the other gentleman is telling Henry that I'm not there, that I'm gone with the Audi, that my Lincoln's still there. So you're there to have your friends pick up your belongings, but they're on the phone with you, recorded on my Ring camera, where you're getting information on where I'm at, what vehicles I'm gone in, when you're supposed to have your friends come there to get your stuff. And this is continuously concerning to me. And that's why I added those things in there. And that's why my daughter added other things in to the statement.
Okay, thank you.
And Judge, if I may ask her one question.
Yes.
Has the defendant had any contact with you besides, I know he didn't have contact with you in this incident, but has there been any other attempts besides this incident?
There was an attempt in November.
Was that before or after the defendant had pled guilty?
It was before probation.
So I'll ask you from the time of the plea of this case. Has there been any attempts?
Since probation?
Yes. Okay. Thank you. Judge, I'll ask the court before making their determination. I don't know if we need to adjourn it to confirm with the hospital whether or not there really was, before we can make a informed decision on what to do. Because what if there was never an incident that occurred? I'm not saying that that's the case. Very well may be. but there's been no evidence presented to the court or to myself at this time.
Your Honor, this is a probation violation. Probation violation was that he, with his court's orders, contacted directly or indirectly the victim in this matter. He's pled guilty to that, and evidence has been.
So are you looking for something specific to this case?
Yes, I'm showing the incident itself. I was gonna show Mr. Muhammad if it was okay.
Right. Your Honor, that.
It appears as though the relevance of whether or not the accident actually occurred is as far as the intent or otherwise. So I do find that that would be relevant, whether or not there was an actual incident. What is that, sir? Is it my chart or what is that?
With all over the place.
No.
I got the stitches.
No, what I need to see is which hospital was your daughter at?
It was Henry Ford Wyandotte. I found
You
out
think?
Henry Ford Wyandotte later. But
Hold on. Which hospital did you visit her at?
Henry Ford Wyandotte, Your Honor.
Okay.
At the time, I don't know why I was thinking Beaumont. It just.
So hold on. Does your daughter have my chart set up?
She should. If not, I can get the information from Wyandotte. Henry Ford Wyandotte Hospital. I can get the paperwork from them if you'd like. And I can send it to my probation officer for Mr. Muhammad, whichever one.
Well, Judge, I guess that would involve potentially HIPAA, and I don't think we should go down that rabbit hole.
Let me clarify.
I want to raise it.
I'm not I'm not necessarily looking for what she was treated for or otherwise. What I'm looking for is to see whether or not she was actually at the hospital on January 28th. And so all that has to indicate is something that shows that she was in fact at the hospital January 28th. That's what I'm looking for. I'm not looking for a diagnosis. I'm not looking for anything like that. But
Or my apologies. Or we can just subpoena one of the witnesses to that incident, whether it's a transportation driver or whoever it may be, and just get their position on whether or not that incident occurred. I'm more inclined to believe the defendant. I'm being transparent. However, it's their burden, so I just want to ensure they've satisfied that.
It's whose burden?
it's whose burden?
It's the defendant's burden to show that there's a reason for the violation. It's not the people's burden.
Well, hold on. First of all, really, the only thing I have to decide, because
Whether or not.
he's already pled guilty because he had contact, a third party contact. And it sounds as though the reason for the third party contact, it appears the reason for the third party contact is what Mr. Mohammed's trying to determine if that was even a legitimate
I understand, Your Honor.
basis as far as whether what this court should take into consideration in fashioning its sentence. Would that be accurate?
Correct. Absolutely.
And I do understand that, Your Honor. Yes. What I'm saying is, there is no burden. He's pled guilty and now
Correct.
it's fine. Right.
Autumn, what does the docket look like on the 19th? That would be sufficient time to get the document that would show whether she was or was not in the hospital.
The 19th says covering 28th. You see, state of it.
February 19th?
February 19th.
Okay. What's our docket look like? I know we have the jury selection in the afternoon.
That's fine. And what's happening? So at 8:00 a.m. it says covering 28th BC, and then we're starts at 9.
Okay, how many cases does Mr. Golpa already have?
3.
Oh, okay.
Not too bad. Yeah. That's
Yeah.
2 weeks away. Oh,
Let's set the sentencing in this matter for February 19th at 9 a.m.
okay.
Your Honor, there's a Henry Ford was sending me a survey after I was there
Okay.
on the.
Sir,
Welcome.
sir, what I need is your daughter's date of service. That's what this court needs to see. Date and time.
Okay.
When do you need it by?
You get it.
You have to bring it by the 19th.
Bring by the 19th. Okay.
Okay.
Sure.
So, because I have restrictions from leaving, is it sufficient that I text the probation officer and let her know that I'm on my way to the hospital to get documentation and back? So she know everything that's going on.
Yeah, restrictions from leaving what? Here
To the home.
He's on house arrest, counsel.
Oh, I didn't know that.
Right. So, I mean,
As I said, I didn't do the.
you should, I mean, if your daughter has a MyChart account, or if you set up a MyChart account, you don't even need to go to the hospital. You can get it all online.
I can't get it online. My wife has the passwords on my phone and I still can't get online. I can't get apps.
She has the password to your phone.
She reset my whole phone and changed the password, and she didn't tell you that. Yes, I can show you right now. And I've been asking her for the last 6 months to please give me the password to my phone. All my daughter's pictures when she was born.
Hold on. Do the two of you share an Apple ID
My wife
or
does.
an Apple something or other?
Yeah, we have all our phones is connected.
Okay.
My
Well,
wife did all that.
then you have to connect your phone somewhere else.
She has my old phone. That's how she got in this phone. But she reset everything, and she's changed the passwords. I can't get on my Facebook. I had to make a new Facebook account. I can't get on my Google. I have to go through her password, and I can't get on my emails because she has the passwords, and she keeps giving me different names, and they're not the correct names for the password. So I'm locked out of everything for the last 6 months. And I was wondering, well, why would you do that? Why would you reset?
Okay, I'm not getting into why or anything like that. Speak to your divorce attorneys so that you can all figure that out. But in any event, your daughter's are you chewing gum?
True with Tom.
Chewing what?
Tom, I do that.
Your daughter's MyChart isn't connected to the Google or anything else like that. Your daughter's MyChart, if you set it up, then you can set up the password and all that other sort of stuff. Or I would think that when your daughter was discharged from the hospital, you had those papers.
No, but once I set it up, it still come to my email, and I can't get into my email.
Sir, set up a new email and link a new email to the MyChart. It's not that difficult. But do you have the paperwork from when your daughter was discharged? Do you have the paperwork from when your daughter was discharged?
That's what I'm saying. I don't know. You know what? Yes, I do. I do.
Okay, well then great.
I have it. Because James,
Okay, sir, I don't need to know why you have it.
Yes,
Say
bring
we
it back. Okay, I'll bring
So
it
then
back
you
on the
can
19th.
bring it, you can scan and email it or whatever you need to do.
What time?
9 a.m. on the 19th.
And last, I'm sorry.
What's what?
Yeah. And last but not leastly, I have major respect for you, Your Honor, and I would never lie to you. I would never lie to you. And November was not the last time my wife saw me. She lied to you right to your face, and I have proof. My wife stayed with me for 14 days trying to get me back home. And the only reason why I didn't go was because of her daughter.
Just forget the.
And she,
I am not getting into this. I am not going in. I'm not. Nope, not doing it. Not doing it.
Okay, be back on.
All right. See you back on the 19th at 9 a.m.
Thank you, Your Honor. Sorry about that.
Have a good day. Off the record.
Every day in the USA, people find themselves in court.
Good afternoon, sir. Are you Mr. Kenneth Martin?
Good afternoon, sir. Yes, I am.
Very good. We're pleased to have you here today. You've had the benefit of watching attorneys present their case, argue their case while you are waiting for your case to be called. You have, and the attorney opposing you have 15 minutes each to present your arguments. You have the right to reserve 5 of those or less, 15 minutes, if you want to rebut, to respond to what the attorney says. Do you wish to save any time?
Yes, Your Honor. I would like to set aside 5 minutes for
5 minutes, very good. Then the clock will be set for 10 minutes, and that'll be your initial statement. The floor is yours.
Yes, Your Honor. So I'm Kenneth Martin, the appellant in this case. May it please the court, my name is Kenneth Martin, the appellant. This is an appeal from the trial court's denial of a Tennessee Rule of Civil Procedure Rule 60.023, the judgment is void motion. The issue underlying is that because the trial court proceeded to a final judgment without a complaint ever being filed in this case, and without the appellant ever being served with the summons and complaint in the case, violating my foundational principles of due process and the Tennessee Rules of Civil Procedure. According to the Tennessee Rules of Civil Procedure, Rule 3, it says all civil actions are commenced by filing a complaint with the clerk of the court. In this case, there was no complaint filed with the clerk of the court, so the case should have never proceeded in court. There's no record that shows that a complaint was filed with the court, so without a complaint being filed, there's nothing that the judge, had subject matter to rule over, I feel, in this case, Your Honor. And so in addition to that, Tennessee Rules of Civil Procedure Rule 4.05 requires that Mr. Martin be served with a summons to establish personal jurisdiction. There was no summons that I was served with for the case, Your Honor. So the court lacked personal jurisdiction to make any orders or judgments against me in the case. And without service of process, the court lacked personal jurisdiction pursuant to Tennessee Rules of Civil Procedure 12.02, lack of jurisdiction over the person to enter any valid judgments or orders against Mr. Martin. In addition to that, Tennessee Rules of Civil Procedure Rule 4.011, this rule says that upon the filing of a complaint, the clerk of the court shall promptly issue the required summons and cause it. And in this case, Heather L. Moore, without the filing of a complaint, issued summons in this case. As a result, Heather L. Moore had no legal justification to issue the summons in this case because there was no complaint filed with the court. And then the state of Tennessee, XRL, and Ms. Barrett failed to serve the summons upon me for the case, Your Honor. So I was not legally before the court in this case. Pursuant to Tennessee Rules of Civil Procedure Rule 4.012, Mr. Martin was never served with the summons for the February 6th case. This rule says the process server must be identified by name and address on the return. There is no record of a process server being identified by name and address for a summons and complaint for the case on February 6th, Your Honor. And then under Tennessee Rules of Civil Procedure Rule 4.02, it outlines all the requirements that must be met for a summons. And nowhere in the record does it show that a summons meets those legal requirements that were served upon me, Your Honor. And so those requirements are that there was, Mr. Martin was never issued a summons in the name of the state of Tennessee for the case. Mr. Martin was never issued a summons that was dated and signed by the clerk of the court for the case. Never received a summons that contained the name of the court and the county. Mr. Martin never received a summons with the title of the action listed as a summons that required Mr. Martin to appear in court on February 6th. Mr. Martin never received a summons that was directed to him for the February 6th case. And Mr. Martin never received a summons that stated the time within which these rules required the defendant myself to appear and defend, Your Honor. Consequently, Ms. Barrett in the state of Tennessee XRL failed to serve Mr. Martin with the summons that meet the legal requirements of Tennessee Rules of Civil Procedure 4.02. All right, Tennessee Rules of Civil Procedure Rule 4.031, Your Honor, says that the person serving the summons shall promptly make proof of service to the court and shall identify the person served and shall describe the manner of service. There's no record of any person promptly making proof of service to the court and identifying Mr. Martin as the person served or described the manner of which Mr. Martin was served for the February 6th case, Your Honor. And then, what is this? Under Tennessee Rules of Civil Procedure Rule 4.032, it says that the person making the service shall endorse over his or her signature on the original summons the date of mailing a certified copy of the summons and a copy of the complaint to the defendant and the date of receipt from the defendant. There is no record that the person making service endorsed over his or her signature on the original summons, Your Honor, the date of mailing a certified copy of the summons and a copy of the complaint to Mr. Martin, and the date of the receipt of return from Mr. Martin. As a result, Mr. Martin and, Mrs. Barrett and the state of Tennessee ex rel have failed to meet the legal requirements pursuant to Tennessee Rules of Civil Procedure Rule 4.032. All right. Under Tennessee's Rule of Civil Procedure Rule 4.05, this rule requires that for service of process to be met, that I be served with a summons and complaint. Because I was never served with a summons and complaint, service of process was not met in this case, Your Honor. And Ms. Barrett and them failed to meet the service of process requirements pursuant to that rule, Your Honor. And so Mr. Martin was never properly served with the summons and complaint as legally required pursuant to Tennessee Rules of Civil Procedure Rule 4.052, which clearly states that the service of process pursuant to this rule 4.05 shall include a copy of the summons and of the complaint. Therefore, Mr. Martin was not properly before the court. For that reason, this is insufficiency of service of process pursuant to Tennessee Rules of Civil Procedure 12.025, Your Honor. As a result, the Chancery Court of Montgomery County, Tennessee at Clarksville failed to acquire personal jurisdiction over Mr. Martin before making any orders or judgments against Mr. Martin. Therefore, the Chancery Court lacked personal jurisdiction pursuant to Tennessee Rules of Civil Procedure 12.022, lack of jurisdiction over the person to enter any judgments or orders against Mr. Martin, Your Honor. So, conclusion for this, Your Honor, will be that no summons and complaint were served. The court lacked personal jurisdiction over Mr. Martin. Consequently, the judgment should be void under Tennessee Rules of Civil Procedure Rule 60.023. And that's what I have, Your Honor.
All right. Thank you, Mr. Martin. We'll hear from you again after we hear from the attorney.
Yes, Your Honor.
Good afternoon.
Good afternoon, Your Honor. Rebecca Garman from the Montgomery County Bar. I represent Magistrate Travis and the Clerk and Master Heather Moore. Mr. Barnett represents the state of Tennessee defendants, and I will ask that the court allow him 7 minutes. I'm going to take the first 8 minutes, and
Very
he'll
good.
argue for the final
All right.
7
We'll
minutes.
set your clock for 8 minutes. Thank you.
Thank you, Your Honor. I want to address first a brief overview of the facts in this case. Appellant Mr. Martin just talked a lot about a complaint and a summons, and I want the court to be aware that all of those things that he was talking about are from a completely different case. They're not the case that we're here on today, but they are related, so I would like to give a brief overview of this prior case. In March of 2018, plaintiff appellant filed a petition or a complaint for divorce against defendant Natasha Barnett. That divorce was finalized in May of 2019, and that was the end of the divorce at that time. However, in January of 2022, a petition to set child support was filed on behalf of by the state of Tennessee on behalf of Ms. Barnett. Several summonses were issued for that petition to set child support. That was appropriate. Many of those summonses were returned as unable to be served, but in November of 2022, a new summons was issued to Mr. Martin, and it was served, I believe, November 12 of 2022. That document, the return of service, along with an affidavit from the private process server, is in the record. It's in volume 4 of the record. It starts on page 439 and goes from there. But there is a summons that was issued appropriately on the petition to set child support that was issued in November of 2022, was served in person on Mr. Barnett in November of 2022 as well. There was a return of service filed. The affidavit from the private process server is listed on that document. A description of the individual he served, as well as his name and location, are also listed. So all of that is proper and appropriate. After that, the trial for the petition was set for hearing on February 6th of 2023. Mr. Martin appeared at that trial. I believe he appeared in person, and it was ruled over by Magistrate Judge Travis. Mr. Martin presented proof, as far as we can tell, and fully participated in that hearing without any indication that he was not properly before the court. It is our position that he appeared at that February 2023 trial as a general appearance. Magistrate Travis then issued her findings and recommendations, where she established a monthly child support obligation for Mr. Martin, as well as child support arrearages. On February 14 of 2023, an order confirming those findings and the recommendations was entered by the chancellor. That will be the final order establishing the child support obligation and the arrearages. 30 days passed, there was no appeal. In fact, there has never been an appeal of that order. In January of 2024, a new petition to modify the child support was filed by the state of Tennessee on behalf of Mr. Martin. That matter was set for a hearing on June 3 of 2024, and at that time, Mr. Martin asked that the petition be dismissed. The petition was dismissed. Ironically, though, that same day, June 3 of 2024, Mr. Martin turned around and filed this lawsuit that we're here on today. So there are two separate lawsuits, and the lawsuit Mr. Martin has talked about during his argument were the previous divorce file and child support, which was filed in Montgomery County Chancery Court and had a docket number of DI-18-186. This this lawsuit that we're here on today is a completely different lawsuit. It is candidly difficult to understand the precise claims that he's making, although it seems to be a collateral attack on the child support obligation that he has been entered. On behalf of Magistrate Travis, we will say that no summons has ever been issued to her, so we contend she is not before the court. Only a limited appearance was submitted on her behalf, along with the Rule 12 motion. I did not hear any discussion about Magistrate Travis at all from Mr. Martin during his oral argument, so I'm not even clear if he's still attempting to assert a claim against her. But if he is, we contend that she's not properly before the court because no summons was issued. So there's insufficient process and also insufficient service of process. Alternatively, she was the child support magistrate at the time. Any activities that she performed in this case for which Mr. Martin may complain, she is immune from those as judicial duties. Moving on to the clerk and master, we contend she is also immune because any issues relating to an issuance of a summons or anything with paperwork in the pleadings are part of her quasi-judicial duties, and she is immune from those. All I heard Mr. Martin mention today about the clerk and master, Heather Moore, is that she issued a summons without a complaint. Candidly, that's mistaken. There was a petition to set child support, which is a proper petition, which was filed in the divorce and child support case. That is a complaint or petition, a proper initiating pleading in this case. The clerk and master, at the request of the state of Tennessee, who had submitted the petition, issued a summons. In fact, issued several summonses because the first were not properly served on Mr. Martin. But there was a summons that was issued in November of 2022 and properly served on him later that month. So None of those all of those activities that the clerk and master Moore performed were quasi-judicial functions for which she is entitled to immunity. I also want to address a few things that were addressed in Mr. Martin's brief, although I did not hear about them today. There was a significant discussion in the brief and at the trial court level about the clerk and master not signing some of the pleadings, some of the summonses, and instead the deputy clerks were signing those. That is absolutely appropriate under the law, and we have cited those provisions in our brief. The second dealt with a requirement under Federal Rule of Civil Procedure 4, which required the inclusion or the asphyxiation of a court seal. There is no such requirement of putting a court seal on pleadings in the Tennessee Rules of Civil Procedure, and the Federal Rules of Civil Procedure do not apply in this case. We have outlined for your honors and for this court the supremacy clause allegations that Mr. Martin made. I did not hear him discuss those today, so we will rely on our brief on those options and contend that the trial court was correct, that the Rule 12 motions to dismiss Magistrate Travis and Clerk and Master Moore were appropriate and should be affirmed on appeal. I will say, and just want to reiterate, that the child support judgment is not void, as Mr. Martin argues, because there was a proper petition to set child support. There was a summons that was issued for that petition, and that summons was properly served upon Mr. Martin in person in November of 2022. But regardless, if there was some issue with service of process, he appeared and has waived any service of process issue by a general appearance and participation at the trial court level in February of 2023.
All right, thank you very much. Good afternoon.
Good afternoon, Your Honor. My name is Wade Barnett from the Tennessee Attorney General's Office, and I represent the state defendants, the state of Tennessee, the Child Support Office of Montgomery County, and the Chancery Court of Montgomery County. Just for purposes of clarification, General Scrimeti and General Nash were named as parties on appeal. They were never named parties at the trial court level, but just to clarify that for the record. As Ms. Garman stated, this case is an impermissible collateral attack on a child support judgment. In the state defendants' arguments, there's two arguments today. First, the state defendants would argue that Mr. Martin has waived all challenge to the trial court's judgment on appeal due to deficient briefing. Rules of appellate procedure and this court's rules outlines certain requirements for briefing. Mr. Martin did not comply with those. For example, in his statement of issues, he doesn't address many of the grounds that the trial court relied on in dismissing the amended complaint, including sovereign immunity, insufficient service of process, relief under Rule 60, and the statute of limitations. His statement of facts and statement of the case contain legal argument, and he does not cite to the record whatsoever. Yes, he is a pro se litigant, but pro se litigants are have some leeway, but they still have to follow the same substantive and procedural requirements as attorneys, and that was not done so here. So the state defendants would argue that all challenges to the trial court's judgment here have been waived. In the alternative, the state defendants asked this court to affirm the trial court's judgment. First, the state defendants have sovereign immunity. Mr. Martin has asked for $10 million in damages. Under Tennessee law, the party cannot seek monetary damages from the state unless the state consents or waives sovereign immunity. That has not been done so here. And plaintiff does not cite any applicable authority that waives sovereign immunity. There's also insufficient service of process. Under the rules of civil procedure, in order to serve the state, you have to serve the attorney general or to an assistant attorney general. In this case, Mr. Martin served an assistant district attorney general. He argues that that is proper. It's not. This court has held that in order to effectuate proper service, there has to be strict compliance with Rule 4. And Rule 4 explicitly states it has to be served on the Attorney General or an Assistant Attorney General, someone like in my position. Likewise, the trial court did not err in finding that Mr. Martin has failed to state a claim. Again, Mr. Martin has tried to issue a collateral attack on the child support judgment based off of lack of personal jurisdiction. He argues that there was no summons, but as Ms. Garman mentioned, there was summons. There was a petition to set support. There was a process server that served him back in November of 2022. And even then, as Ms. Garman mentioned, Mr. Martin made an in-person appearance on February 6th here in Montgomery County. The trial court's order notes that he attended, and he actively participated. He answered questions. He did not raise any applicable Rule 12 defenses at that time. He did not file a notice of appeal. And when the state filed a petition to modify on his behalf, he dismissed that before filing the current complaint before this court. Also, there's a statute of limitations. Constitutional torts have a 1-year statute of limitations in Tennessee. The child support order was entered in February of 2023. His wages were first garnished in April of 23, but he didn't file his complaint until June of 2024, over a year later. So there are a number of different arguments that Mr. Martin has made in his brief regarding Rule 60, equal protection due process claims. However, as stated earlier, he's actively participated in the child support proceedings, and I would rely on the brief for those issues, and if the court has any questions for me, I'm happy to answer those, but that would conclude my argument.
All right, hearing none, thank you, General.
Thank you, Your Honor.
Mr. Martin, you have the opportunity to respond or make your final argument.
All right, Your Honor, the first thing that I would like to address would be, I'm sorry, I don't know your name, ma'am, but the lady over there stated that—
Ms. Garman.
Ms. Garman, yes, ma'am, sorry. That Mr. Martin was served on November of 2022. Well, that is correct, except for what she failed to mention was that summons that I was served with was for a completely different case that was, I believe, on December 5th of 2022. I never appeared in that case. I don't know what happened in that case because it clearly states on that summons that it's a no in-person appearance on that summons. And then from my understanding of the law, excuse my ignorance of the law, Your Honor, but from my understanding of reading several court cases is that if a court lacks personal jurisdiction over a person and a case is proven to be void from the face of the record, which in this case would be because I was never served with a summons or a complaint, the court never had personal jurisdiction over me to enter any judgments or orders against me in the case, that I legally would be able to attack this case. To address Judge Travis, I never had Judge Travis on this case, so I'm not sure why they keep bringing her up for this case. She was mentioned in my original complaint, but I never served her or anything for her to be a part of this case. Then further—
You didn't intend Judge Travis to be a defendant in this case?
No, Your Honor. I never served her or anything. I just made mention of her in the complaint, Your Honor. They mentioned the petition to set support. All right, nowhere in Tennessee Rules of Civil Procedure, Rule 4.05, does it say that a petition to set support meets the legal requirements of Mr. Martin being served with a summons and complaint. The petition to set support fails to address any violations of laws of Ms. Barrett's rights or anything that I did to be brought to court. So I think that all in itself fails to meet the legal requirements of what a complaint is supposed to be before the court. Nowhere in the petition to set support does it allege that I violated any laws or rights. And then without a summons and complaint, I am not required legally to file an answer until after I am served with a summons and complaint pursuant to Tennessee Rules of Civil Procedure Rule 12.01 says a defendant shall serve an answer within 30 days after the service of the summons and complaint upon him. Because I was never served with the summons and complaint, I'm legally not required to file a answer, Your Honor. And then to the gentleman, I'm sorry, I don't know your name, sir.
General Barnett.
But to General Barnett's statement about the law saying about the Attorney General, that have to serve the Attorney General. From what I've read in the law, Your Honor, it states any Assistant Attorney General. It doesn't specify in the law that it has to be a state or district Attorney General. It clearly says any Attorney General. So from my interpretation of that law, it's the requirement to serve Assistant Attorney General was met. And then pursuant to rules, Tennessee Rules of Civil Procedure, Rule 60.023, the judgment is void does not have a time limitation on which a person is bound by to challenge a void judgment, Your Honor. And that's all I have, Your Honor.
All right. Thank you, Mr. Martin, for your argument. Your case will be taken under advisement, and a written opinion will be prepared, and the clerk of the court will forward that to you to the address that you have provided to the court.
Yes, Your
All right. And thank you, Ms. Garman and General Barnett. That concludes the docket.
All rise.
Every day in the USA, people find themselves in court. In October of 2024, Judge Mogan issued a permanent injunction ordering Carl Olsiums to stop renting his property completely until he obtained specific state and county licenses. Olsiums did not obtain these licenses. Instead, he continued to rent the property during the summer of 2025, thinking he found a loophole to the rule by only renting for 2 days and offering 5 days for free. The neighbors of this property and plaintiffs in this case filed a motion to hold him in contempt of court in February of 2025. That contempt hearing lasted 5 hours, and it was just the beginning of a year-long judicial headache.
When I scheduled this, you, Mr. Olsiums, told me we only need 2 hours, and I know better. I know better, so I scheduled it for all day. I blocked my whole day off knowing better because it is taking Mr. Olsiums, it's going to take him 3 hours to cross-examine Mr. Brimacombe. And then after you're done, we get to move on to redirect with Mr. Anderson. And then we get to move on to recross with you, probably for another 2 hours, of Mr. Brimacombe. And then we get to see if we have other witnesses. And then maybe you'll have a few minutes to provide your own testimony. Okay? So again, I would cut it a little bit short and I would get to the point a lot faster than you're getting. Because today's your day. All right? Because again, you only asked for a few hours and I gave you the whole day knowing better. So let's kind of do it a little quicker, okay? Next question.
Mr. Olsiums spent the next 2 hours pretending to be a lawyer and creating ever so much more frustration. Facing pending contempt, Mr. Olsiums filed for an appeal to the original injunction, thinking that would delay all decisions in the contempt matter.
I just needed to understand if nobody's seeking any monetary amount for any of the alleged timber trees that were cut, that damage to that big tree that was talked about, the no trespassing signs, the damage to the easement road.
That's because there were no damages.
I'm not talking to you. But, and the fact that there were perhaps discarded waste allegations, but for those alleged actions and alleged damages, there's no monetary amount sought. Is that correct?
It is correct with respect to a specific dollar amount, but all of that goes to my client's inability to enjoy their property to a certain extent. And those numbers are in our submission to the court from our closing argument and go to basically my clients having to be the caretakers up there when the Alsiums are 100 miles away, which I put in my brief is also a violation of Burnett County ordinance. And so all of that, Your Honor, goes to my clients basically working when they're up there at times, dealing with renters who are asking them questions, who are getting stranded on the lake, et cetera. And so all of that, again, goes to the $630,000 of ill-gotten gains that the Alsiums received because they were running a business when they shouldn't have and where they shouldn't have. So there aren't specific dollar amounts that go with those, Your Honor, but it's all part of the overall claim that is my client's inability to enjoy their property and have this serene, tranquil experience that they expected when they went up there.
Okay, Mr. Alsiums.
And again, that's nonsense. It's only a few weeks every summer. There are no damages. Again, they're just reaching. They're just basically trying to get us to stop renting our property. Not enjoying your property. Again, he was able to go to the property. He's able to get to his property. There weren't 15, again, the evidence shows there weren't 15 cars parked there. So again, this is all a reach. There are no damages. There's no contempt. And I've been in compliance with the 10-day order from last year and this year as well.
Okay, thank you. Now, the only other thing that I'm going to need then to wrap this all up is the argument for attorney's fees. And if you believe that attorney's fees should be granted, and if you believe that they should not be granted. Mr. Anderson is going to argue that they should be granted, and he's going to find a statute that says that there's authority to do so. And would you like to have Mr. Anderson file first and you do a response, or would you like it to be a dual filing, Mr. Alsiums?
He can file first.
Okay. So, Mr. Anderson, do you believe that you can have both of your filings by the 3rd, or do you need additional time?
3rd's fine.
All right, so have both of your filings by the 3rd. And Mr. Alsiums, your 21 SC case will be due the 3rd, but your attorney's fees matter will be due on June 10th. Is that okay? Or would you need another, or would you need till June 16th or 17th?
June 17th.
All right, so June 17th, your response can be due, okay? So then that would be the last thing to wrap all of this up, and then I will have everything I need to complete my decision. Okay? All right, thank you.
Your Honor.
In August 2025, contempt orders were finally issued. A $5,000 fine and 90 days in jail, which could be purged if paid by October 27th. The purge was never paid. Now it's February of 2026, 1 year later, and look who's back.
All right, I have a James Bennett and a Debbie Tate. You are muted. Can you unmute and just let me know that you can hear me?
I can hear you.
Okay, I can hear
Thank
you,
you.
Mr. Bennett. Ms.
Okay.
Tate, can you hear me?
Thank you.
I can hear you, yes.
Excellent. We are not in need of your testimony at this time. I'm gonna guess that we're going to sequester witnesses. Do you know what that means, Mr. Alsiums, to
Mhm.
sequester? Are you gonna ask to have all witnesses sequestered until they provide testimony?
I don't think it's necessary.
Okay, then that's fine. Then you can hang out and you can just listen, and when we need you, we'll call you and I'll swear you in, okay?
Okay.
Okay.
One question I do have, I have an exhibit
Yeah, you need to
that
come. up
Mr.
with-
Bennett is I'm gonna ask him to look at, so.
Oh, he can't. He's not here.
Right, so that's my question.
And there was adequate notice that I granted him the ability to be here by video. So what you needed to do was provide it to Mr. Anderson so that he could give it to Mr. Tate or the testimony, but there's no way.
Well, I can introduce it with my testimony as well.
If it's a document that you prepared, yes.
Yes.
All right, okay. We will be ready to go here in a minute. Do you have, if you have exhibits, you do have to get them marked. All right, while we're doing all this little getting ready thing, I'm just gonna put the courtroom into the waiting room and we'll be ready to go, okay? When I come back.
Hi, can you see me?
I can. I'm assuming you could see me too then.
You too. Okay, now we just sit
All
here
right.
and wait. Oh,
Nope, we're ready to go.
Sorry.
Nope, that's okay. All right. We will go on the record in the matter 23 CV86, Rick Brimacone et al. Versus Carl Olsiums et al. Appearances are, we have parties appearing here today. Carl Olsiums appears in person without counsel. We do have Rick Brimacone appearing with counsel Christopher Anderson. I'm not sure which others of the plaintiffs do appear here today for the hearing. They're not required to appear, but we do have the lead, Mr. Brimacone, with Mr. Anderson. We're set here today in this matter for the plaintiff's motion against Mr. Olsiums as it relates to a contempt. And the court will take up Mr. Olsiums. I think you filed a motion to stay the court's order unless you are not continuing to seek that.
Yeah, well, it's under appeal, and I just filed a motion to basically stay everything until the Court of Appeals rules.
Right, so I will hear that motion,
Right.
but it's not an automatic stay. It doesn't.
No, I
come
know,
into
that's why I'm,
But yeah, I will hear that motion, and that is exactly why we needed to have this hearing timely. Okay, am I missing anything as it relates to motions, Mr. Anderson?
I don't believe so.
Mr. Olsiums?
I don't think so.
Okay, off the record, the court did inquire as to whether or not anyone was requesting sequestration of witnesses. It was told to the court that no one is asking for sequestration, correct, Mr. Anderson?
We are not, Your Honor, that's correct.
Correct, Mr. Olsiums?
Correct.
Okay, so I do not have to sequester witnesses. Therefore, Mr. Anderson, I will take your motion up first, and then I will move on to Mr. Olsiums.
You want me to call my first witness then?
Yes, please.
And one other thing, Mr. and Mrs. Miller are present in the courtroom today too, just for the record.
Thank you, Mr. and Mrs. Miller. So that would be John and Elizabeth Miller. First and foremost, since it's been a while and I have read everything, I've read it. I have it in hard copy. I have it on the electronic copy. But can I get a brief argument from both sides to the contempt first before we take testimony?
Sure.
Just briefly.
Yeah, simply put, Your Honor, there's an order from the court requiring Mr. Olsiums to get permission from the license from DATCP along with the. I'm sorry. Most people don't want to hear me that loud.
I can turn it down if I need, but she needs to hear everything.
Yeah. An order from the court of October of 2024 that requires Mr. Olsiums to not rent his property unless he has the proper permission and licensure from the state and the county. He is, by his own admission, he does not have that and has never applied for it as far as I know. Last summer, in the affidavit of Rick Brimacone, it's also outlined that there was 5 different periods of rental. And we can go through the specifics of that in testimony, but there was 1 in May, 1 in June, 1 in July, and 2 in August, all in violation of the court's order. And so therefore, Your Honor, the court's order was violated again, and it was already violated previously by Mr. Olsiums. And so we are asking for a finding of contempt and appropriate sanctions relating to that contempt.
All right, thank you. All right, Mr. Olsiums.
In response, the order doesn't say I need a license. The order says permission of the county. And the ordinance says it's 10 days or less. And it's my intention to rent the property for 10 days.
All right.
And that's what I'm claiming I did.
All right. The order says what the order says, and I will have to interpret my own language in my order when we get to that. But Mr. Anderson, please call your first witness.
Call Carl Olsiums.
Mr. Olsiums, please come forward. You're going to raise your right hand. You're going to be sworn in and come have a seat at the witness stand.
Do you affirm that the testimony you're about to provide in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, come have a seat. You may not bring anything with you.
Well,
Not at this time. Not at this time. You're being called as an adverse witness.
Yep.
You may approach if you would. Thank you.
Mr. Olsiums, you rented property in Burnett County over the summer of 2025. Is that true?
Yes.
Okay, and you rented that property May 24th through May 26th. Is that accurate?
I don't recall the exact dates.
Okay, you recall renting it over Memorial Day weekend?
I do, yes.
Okay. Did you rent the property in June of 2025, June 6th through 8th?
Again, I don't recall the exact dates.
Okay, do you recall renting the property in June?
I don't know specifically.
Okay. Do you recall renting the property in July?
Yes, I do.
Okay. And that was to a James Bennett, true?
Yes.
Okay. And you rented that property from July 19th through July 26th?
I don't recall the exact dates, but I have the rental agreement there as an exhibit.
Okay. They were at the property from July 19th through July 26th, as far as you recall?
I don't recall the exact dates, no.
Okay. Were they there for approximately a week?
I believe so, but again, I don't recall the exact dates.
Okay, you think that would be on your rental exhibit?
It's on the rental agreement, yeah.
Okay. Do you recall renting your property in August of 2025, August 8th through the 15th?
I don't. No, I don't know. I don't recall.
You don't know the exact dates again?
No.
Okay. But you did rent it in August to some group for approximately a week again. Is that accurate?
I don't recall.
You don't know if you did that or not?
No. Mm-hmm.
And did you rent out your
Sorry, I don't mean to interrupt, but I think you said
I said no. Yeah, I said
Please don't, and I'm gonna let everybody know, please don't go the court reporter needs a yes, a no, a maybe, because otherwise it's very difficult for her to take it down. Plus, if this does go to the Court of Appeals, it's difficult for them to interpret
I know.
Okay.
I apologize.
Thank you.
Mr. Olsiums, did you rent your property out from August 28th through September 1st of 2025?
Is that the Labor Day weekend?
I believe that is Labor Day weekend.
Yes, I did.
Okay. You remember who you rented that to?
I don't remember the person's exact name, no.
Okay. I've put in front of you something marked as Exhibit 1. Do you have that in front of you?
Yes.
Okay. And do you recognize or do you know what this is?
I don't know.
Okay.
Thank you.
I've just handed you what's also been marked as Exhibit 2. Do you recognize that?
Not specifically, no.
Okay. You see where it says inbox, Northwoods Heaven on Island in beautiful Northwest Wisconsin?
Yes.
Okay. It says, "Hi, Carl. We headed out." It says we headed out of yesterday around 6 a.m. Excuse me. Do you see where it says that?
Yes.
Okay. Appears to be a communication to you. Do you agree?
Yes.
Okay. Do you recall receiving that communication?
Not specifically, no, but this is the communications portal in VRBO. So,
Okay, and that's the platform that you use to rent out the property?
yes,
And this, from what you can tell, was a communication from Robbie. Do you see that down below in the main body?
yes,
Okay, and is it Robbie Lang? Is that who you rented the property out to in over the Labor Day weekend?
again, I don't remember the specific name.
Okay. Would you disagree with the affidavit that Mr. Lang filed in this case, that he rented it over Labor Day weekend from you?
No, I testified that somebody did. I just don't remember his name.
Okay. Your Honor, we will offer exhibits 1 and 2 as communication through VRBO that Mr. Alsiums had either with the platform or Mr. Lang.
Your Honor, can I grab that water real quick?
Mr. Anderson, can you please bring that to him?
I will.
Thank you. All right, then Mr. Olsiums asked to exhibit 1, exhibit 2. He is requesting the court receive them. Any objections?
No.
Received.
Mr. Alsiums, you charged Debbie Tate to rent the property over Memorial Day weekend, true?
Again, I don't remember exactly who it was.
Okay, but you charged whoever rented the property over Memorial Day weekend, you charged them to rent it from you, true?
Yes.
Okay. Do you recall how much?
I don't know.
Okay. As far as the people that were there June, it appears just a short stay, June 6th through the 8th. You charged them to rent the property from you, true?
I don't recall.
You don't know that?
I don't remember. I don't recall those exact dates.
Okay.
And
whoever rented it from you in June, though, you charged them rent. Is that true?
I don't remember renting it June 6th. I don't remember that. I don't recall that.
Okay. July 19th through the 26th, you charged those folks to rent it from you?
Yes.
Okay. And same with August 8th through the 15th, you charged them to rent it from you as well?
No, again, I don't recall that date or that time.
Okay.
Do you just not recall the August one, or are you saying you don't recall the July and the August one?
I don't recall the August one. I recall the July one, but not the August one.
Okay, thank you.
Your Honor, I have no further questions for Mr. Alsiums at this time.
All right, Mr. Olsiums, you are here as an adverse witness testifying right here today. You will get an opportunity to provide all the testimony you want in a different form and fashion, but right now, you have been Mr. Anderson's witness. Therefore, with regards to his questions asked and his questions only, do you have additional information you want the court to know? Otherwise, again, you will have an opportunity on your own to present your whole argument.
I don't recall the June rental, and I don't recall the August rental. I do recall the Labor Day, Memorial Day, and the July rental. The July rental, I have the rental agreement as an exhibit, which I'll show the court later.
Okay.
Okay.
Anything else you want me to know off of his questions?
That's it.
All right, thank you. You may be seated, unless you had redirect off of that, but
I don't think I need it.
all right, thank you. You may be
Exhibits
seated.
back.
Just leave them at the witness stand. Thank you. All right, Mr. Anderson, next witness.
Call James Bennett.
Mr. Bennett is on
Yes.
yes, there you are. You are physically on the Zoom. Mr. Bennett, I am going to have you raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. You may begin.
Mr. Bennett, please state your name, spelling your last, please.
James M. Bennett, Bennett.
And where do you live, sir?
I live in Rockford, Illinois. Would you like my full address?
That's fine. Did you rent property in northern Wisconsin in July of 2025?
Yes,
Okay, and do you recall renting that from Carl Alsiums?
yes,
When you rented it, did you go through a internet service, VRBO?
yes.
How long were you and your group at the property in July of 2025?
We were there from July 19th until July 26th.
Okay, so you're there 7 nights?
Correct.
And how many were in your group that stayed at the property?
There were 14 of us.
Do you recall how many vehicles were up there?
There were 5, I believe.
Yeah. Any recreational vehicles of any sort?
We did bring our boat, which was parked on the water at the dock, and it was put in at a public launch point.
Okay. What was the purpose of your trip to northern Wisconsin that day or that week?
It was our yearly family vacation.
What I'm assuming, so it's a vacation. I'm assuming you did vacation things, beach, water, things like that.
Yes, exactly.
Okay. How was your stay up in northern Wisconsin?
It was very nice. The weather cooperated, and we had a great time.
Good. Do you know how much you paid for that rental?
Yes, I have it in front of me. It was the total was 6,000.
Yeah.
Mr. Bennett,
Oh,
Yes.
hold on, Mr. Bennett.
I have to give you direction because witnesses aren't permitted to testify using their documents. You may refresh your recollection as to what you paid. Once you refresh your recollection, please not look at the document and let me know or answer the question.
So, Your Honor, I have exhibits for I have one exhibit at this point in time for Mr. Bennett. I've provided it to him in advance, and I have copies for everybody here. I had the one marked by the clerk. Obviously, he doesn't have that one, but
that's fine.
Is that all right?
Yes.
All right. Where would you like me to put this up there? The rest?
Just give it to me. I'll just hold on to both of them. Thank you. All right, Mr. Anderson.
Thank you, Your Honor. Mr. Bennett, you began to talk about a document that you may have been looking at. In the upper left-hand corner, is there a VRBO emblem?
Yes.
Okay, and then does it say get the app, USD, and some other words?
Yes.
Okay, and below that, does it say pricing?
Yes.
Okay, and at the bottom of the page, there's a heading that says booking made easy. Is that on yours?
Yes.
Okay. And in the middle of the page, it says price details, and then it goes through a price and has payments, payment 1 paid, and it has a number there. Do you see that?
Yes.
Is that what you were looking at to refresh your memory?
Yes, it is.
Okay. Your Honor, he has Exhibit 3 in front of him. I would submit to the court.
All right, any objection?
No.
Received.
Mr. Bennett, in looking at Exhibit 3, it says $6,950.48. Is that what you paid?
Yes, it is.
Okay, and that was to stay at the property for 8 days and 7 nights. Is that accurate?
Yes.
And when you rented this property, when you went through VRBO, that was, or you understood it to be $809.29 per night for 7 nights. Is that what your understanding was when you rented it?
Yes.
Thank you.
Mr. Bennett, I believe you also have a document in front of you that we've labeled here as Exhibit 5. The first page, I believe I'm sorry, 4, thank you. At the top of the first page, it says booking confirmation. Do you have that?
Yes, I do.
Okay, and then it appears to be a letter. It says, Dear James. Do you see that?
Yes.
Okay. And then the second page, just to make sure it's the same document, the second page at the top says rental agreement. Do you see that?
Yes.
Okay. And this entire exhibit consists of 5 pages. Is that accurate?
Yes.
Okay. And I would submit that he has Exhibit 4 in front of him at this point.
All right. Are you requesting the court receive it?
I mean, well,
I'm sorry.
I'll lay some foundation maybe, but
Yeah,
Exhibit
sorry,
3, I would ask.
I was trying to look at something related to this, and I missed your question. He has it in front of him. Thank you.
Okay. I would offer Exhibit 3 at this time, though.
Mr. Olseams, any objection to Exhibit 3?
No.
It is received.
So you're not offering 4?
Not yet. He has to lay foundation. I jumped forward a bit. Continue, Mr. Anderson.
Thank you, Your Honor. Mr. Bennett, when did you book, or how far in advance did you book your reservation at this property on VRBO?
If memory serves, it would have been about 7 to 8 months.
Okay. And then looking at Exhibit 4, it says booking confirmation and then rental agreement. Do you know how you received this document?
Yes, we received a link to it in the verbal messaging app, the VRBO messaging app.
Okay, and do you remember when you received this document?
Yes, we received it the night before our vacation started, about 5 or 6 p.m.
Okay, and so that would have been July 18 of 2025?
Correct.
Okay. And when you received it, well, first of all, when you received it, did you look at it? Did you read it? What did you do with it?
Yes, I looked it over and then signed it.
Okay. And was it requested that you send it back somewhere?
Yes, it was. Carl Alsiams requested that we sign it and send him a confirmation.
Okay. And when you received it, what were you in the middle of doing?
We were preparing for a week-long vacation. So we were packing our bags. I was loading the vehicles, the truck, the boat. My 5 children had dropped off their luggage and their coolers, which I usually load up in my vehicles because I have a lot more space. So I was in the process of preparing for our vacation.
Okay. At some point in time later that day, did you look at this booking confirmation rental agreement again?
I did after my wife brought it to my attention that he had showed that part of the stay was complimentary and that we actually only paid for 2 days and that the rest was complimentary. She brought that to my attention and then I looked it over again.
Okay. Did that give you any concern?
Yes, actually a great deal. We were concerned that he may have been trying to leave himself an out to force us to leave early. Our thought was that maybe he had double booked it and was giving himself a reason to evict us early.
Okay. Ultimately, you were able to stay for the entire 7 nights, 8 days. Is that true?
Yes.
Yeah. Would you have paid nearly $7,000 for a 2-night rental?
No.
Okay. Your understanding was that you paid for 7 nights, $7,000 almost for 7 nights and 8 days. Is that correct?
That is correct.
Your Honor, we'll offer Exhibit 4.
Mr. Olseams.
No objection.
It is received.
No further questions of this witness, Your Honor.
Mr. Olseams, questions?
Just a couple.
Okay, you may proceed.
So can I call you Jim? Is that okay?
Yes, that's fine.
So, so Jim, you paid VRBO directly, correct?
Correct.
And looking at the pricing, you paid a service fee, which, by the way, do you know what a service fee is on Exhibit 3?
I guess I assumed that it was a fee paid to VRBO.
Okay, so that's not money that went to me, correct?
Objection.
I don't know.
That went to-
Objection.
When there's an objection to all the witnesses who will be testifying, if somebody says either Mr. Olsiams or Mr. Anderson says objection, you need to stop talking so that I have an opportunity to rule on that objection. So the answer or the question was, if he knew what that service fee was and that it did not go to Mr. Olsiams or something to that effect. I could read word for word if I need to, but that is an effect of what was asked. You objected.
Foundation and speculation is the objection.
Any response?
It's not speculation. He's the one that made the payment. He knows what he's paying for.
Well, that's not a legal argument. It is sustained. So you have to build a foundation for that information to come in, or the relevance.
Well, the relevance is that.
I'm not having you argue that to me. I'm just saying that in your questioning to Mr. Bennett.
Okay. So Jim, is it your understanding that that money was to go to me or to VRBO? The service
Are you
fee?
specifically asking about the service fee?
Yes. Is it your understanding that was to go to me or VRBO?
Objection relevance, Your Honor.
Sustained.
The tax, the next item is tax. Was your understanding that was to go to me or to the local governing authority?
Same objection, Your Honor.
Sustained.
You made in your testimony, you said 8 days and 7 nights. Isn't it 7 days and 7 nights? Not 8 days and 7 nights, correct?
I'm sorry, could you repeat the question?
You testified that you stayed 8 days and 7 nights. Isn't it correct that you stayed 7 days and 7 nights?
I think that would depend if we count the day that we packed up and left that morning. If we count that as a day, then we were there for 8 days. We left the premises by 11 o'clock that day, but we were there at least part of that day.
Right, but my question goes to the 24-hour unit of a day. For example, if you were to have a 2-day rental, if you checked in the first day and checked out the second day, that would technically be a 24-hour period, but crossed 2 physical days, correct?
Your Honor, I'll object. This is argumentative. It really is an argument that he's trying to make, and it's not a fact. He was there from July 19th through July 26th. How we count the days is an argument, not a fact.
Okay. So Jim, you checked in before 4 p.m. on July 19th, correct?
No, we checked in at 4 p.m.
Okay, on July 19th.
Correct, on July 19th.
Okay, and when did you leave the property? What time and day?
He's already answered. July 26th, 11 a.m.
Okay.
Sorry, I wasn't going to wait for an objection to ask the answer.
Did you pay a damage deposit?
Objection relevance.
Sustained.
And did you rent the pontoon boat?
No.
And did you cause any kind of disturbance at the property?
Objection relevance.
Sustained.
Were the police called to the property all during your stay?
Objection relevance.
Sustained.
No further questions.
Redirect.
None.
All right. Thank you, Mr. Bennett. You are released. Unless I have any inclination that we may need him for a rebuttal witness, but I guess you would be able to contact him if we do need him, correct?
Yes.
All right. You are released. Thank you, Mr. Bennett. Next
welcome.
witness.
Your Honor, we call Debbie Tate.
Debbie Tate, can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may begin. First, it's Debbie Tate, Debbie, Tate, Tait, correct?
Correct.
All right, thank you.
Thank you, Your Honor. Ms. Tate, where do you live?
I live in Prior Lake, Minnesota.
Okay. And did you rent property in northern Wisconsin in May of 2025?
Yes.
Did you book your reservation through VRBO?
Yes.
And are you aware of who the owner was at that time?
Yes.
And was that Mr. Alsiums?
Yes.
How long were you and your group on the property in northern Wisconsin?
2 days.
Okay. May 24 through May 26?
Well, I guess technically 3 days if we're going to do that.
And I don't really care about that too much, but 2
Yeah.
nights? You stay there 2 nights?
2 nights, correct.
Okay. How many were in your group at the property?
There was 12 total, one night, and one night there was 10.
What was the purpose of your trip up north?
We brought side-by-sides up and we went on local trails in Wisconsin. My mom is very sick with dementia, so we just had a family. It was me and my siblings and my parents. So it was just a quick family getaway.
Good. And how was your stay up there?
It was very nice.
Good. You had a good family time?
Great family time. Thank you.
You said you went on trails. Did you have many vehicles or ATVs up there?
Yeah, we had, I was trying to remember, we had at least 5 vehicles, probably 6 when we had 12 people there. We had 6, plus we had trailers with side-by-sides on them. Probably, if I can recall, we had 5 side-by-sides, so 5 trailers.
Okay. Do you know how much you paid for the rental?
Yes.
Okay, and you have a document in front of you as well. Is that true?
Yes.
Okay, and well, may I approach the bench, Your Honor?
May. Thank you.
Ms. Tate, we have a document in court here that we've labeled as Exhibit 5. I believe it's the document that you have in front, one of the documents that you have in front of you.
Yes.
At the top, it says it has a time of 10:05. Is that correct?
On Exhibit 5, I don't have that on my.
Do you have a document that has pricing at the top?
Can I show you a picture and ask you if that's what you're asking me?
Yes, and I may be able to see better because you are really close to me, but if you show it, maybe I can see it better than Mr. Anderson.
Okay.
But maybe not.
This one?
No, that is not it.
That's Exhibit 6.
It is an exhibit that has 10:05 on the top with 5G full bars, full battery. Says pricing.
Can I show you what I have written down as Exhibit 5?
You sure may.
Sure.
Okay. Oh, wait, excuse me. Is this is page 2 of what I had. Is this what you're looking for?
That is not. And I can't show you because you're not going to be able to see, but this is what it looks like.
What I have is this is what I have as Exhibit 6.
That is not it.
That's
That
not
may
it.
be exhibit 6. I'm not aware.
That's not it.
I'm sorry, that exhibit 5.
How many pages are attached to that? It's one page that we have.
Let's go off the record while we are identifying the exhibit.
Sorry, Your Honor.
That's what I have as exhibit 5. And what I have for exhibit 6 is 2 pages.
On the bottom of exhibit 5, it's one page. On the bottom, it says booking made easy. And on top of booking made easy in blue, it says view rewards activity. You've earned $39.80 in one key cash.
Yes, I have that.
I don't have mine with a map on it, so.
That looks different.
What you just read says that right here.
You know, let's.
All right, back on the record, same appearances as previously noted. We are nixing exhibit 5.
Ms. Tate, do you recall how much you paid for the rental in northern Wisconsin?
Yes.
How much was that?
$2,864.33.
Okay.
Record reflect that you did testify to that without looking at a document.
Okay, thank you, Your Honor. And that number you had put in your affidavit previously. Had you reviewed your affidavit prior to today's hearing?
Yes.
Okay. And you paid that through VRBO, correct?
Yes.
Did I receive exhibit 4?
I believe so.
Okay, thank you. I just wanted to
If you didn't, will you?
I will receive them all. I didn't, I forgot to write 4 down that I received it.
Okay. Ms. Tate, you've also indicated that you have what we have marked here as exhibit 6. Do you see that?
Yes.
Okay, and how many pages is that document?
I don't have 6.
I know.
I have 2 pages for exhibit 6, which is possibly exhibit 6 and exhibit 5 that I did back to back. I apologize.
No, I think you're okay.
Thank you.
Ms. Tate, looking at exhibit 6, it says it has another time in the top left corner, 10:03. Do you see that?
Yes.
Okay, and then it says stay in Danbury, and then there's a picture of a house.
Yes.
And that's on the first page. And then on the second page, I think you were showing that to the court or on the camera. Second page, it says pricing, total price, $2,864.33. Do you see that?
Yes.
And then down below it has like a map and there's Birch Island Lake. Is that page 2?
Yes.
Okay. And can you tell me what this is?
This is my receipt when we rented through VRBO for that weekend.
Okay. Your Honor, we will offer exhibit 6.
Mr. Olsiums?
No objection.
Received.
No further questions.
All right, questions, Mr. Olsiums?
So did we nix exhibit 5?
Yes.
Okay, Ms. Tate, you testified that you paid $2,864.33. Is that correct?
Yes, that's correct. Sorry.
And how much of that were fees going to VRBO?
Objection relevance.
Sustained.
And of the $2,864.33, what was the amount that went as a service fee?
Same objection.
Sustained.
And how much went as a tax?
Same objection.
Sustained.
No further questions?
All right, thank you. I'm just gonna direct all parties that the issue here is contempt and renting the property. It has nothing to do with the value you received, the total amount of dollars. So if there's any confusion there, or unless I'm missing something, Mr. Anderson, it's the nights rented, not the dollar amount, correct? That could go into any argument, but it's whether or not the Burnett County ordinance was violated and or state
I think it's whether your order was violated.
and my order, same,
Well, the
yeah.
contempt piece.
right? I'm going with what what
Okay.
Mr. Olsiums is arguing versus
Okay.
my order,
Fair enough.
right?
Can I speak?
Yes. Well, just if it, why are
Relates
you
to this.
arguing?
Well, what he's gonna ultimately argue is that he's gonna try to get the money that was paid to me. So if, for example, if $8,000 was paid and I only received 5, he can't argue that he should get 8 because I never received 8. So that's why I'm going into.
Well, I understand your argument. With regards to what money went
That's why I'm
somewhere else
asking.
versus what went to you. It's not relevant.
Okay.
Mr. Anderson, did you have redirect?
No.
All right, Ms. Tate, you are released. Do not need to continue to stay unless you wish to do so. Otherwise, we're good to go. Next witness,
Thank you,
Call
Your
Rick
Honor.
Call Rick Brimacombe.
Mr. Brimacombe, please come forward, raise your right hand, have a seat at the witness stand.
Do you affirm that the testimony you're about to provide in this matter should be the truth, the whole truth, and nothing but the truth?
Yes.
Begin.
Thank you, Your Honor. Mr. Brimacombe, please state your name, spelling your last.
Richard A. Brimacombe, Brimacomb.
And where do you live, sir?
In St. Louis Park, Minnesota.
You're one of the plaintiffs in this matter, is that true?
Yes, sir.
Okay, you've testified before in this overall lawsuit, is that true?
Yes, sir, multiple times.
Do you own property near or next door to Mr. Alsium's property in Burnett County?
Yes,
Were you at your property during the summer of 2025 on different occasions?
yes.
How much time would you say you spend up in Burnett County in the summer?
Close to 100%.
Okay. When you were at your property in Burnett County, did you notice people coming to the Alsium's property that were not the Alsiums?
Yes.
Okay, and do you recall how many times you observed that?
These 5 times.
Okay. Did you ever contact any of the individuals that were at the Alsium's property in the summer of 2025?
Yes, I spoke to them, yeah.
And I'm going to ask, can you please speak a little bit more directly into the microphone?
Okay.
Thank you.
Sorry.
Mr. Burdick, I'm showing you what's been marked as Exhibit 7.
Mhm.
Do you recognize this document?
Yes,
Okay, and are these pictures of one of the times when individuals were at the Alsium's property?
yes,
Okay, and these are pictures that you took?
yes,
Okay, and I'd turn your attention to pages 3 and 4.
yes,
That appears to be North Memorial Ambulance.
yes.
There's 2 pictures of that. Was it your understanding that an ambulance was called to the Alsium's property that weekend or that time frame?
Yes.
Okay, and do you recall which time frame this was?
That was what time these pictures were?
I'm sorry, which dates? Was that the May date, the June date? Do you recall?
I believe it was the May date. No, sorry, the June date, the second weekend.
Okay. The May date being what Debbie Tate just testified to, her.
Yes, it was not Debbie Tate's weekend.
Mr. Brimacombe, I do have to
Right.
please instruct you that to please wait until Mr. Anderson is fully done with his question before you provide an answer. It's difficult for my court reporter.
Okay.
Thank you, Your Honor.
Apologize.
I would offer Exhibit 7.
Mr. Olsiums?
Objection.
Received.
Mr. Brimacombe, I'm showing you it's been marked as Exhibit 8. Do you recognize that document?
Yes.
Okay, again, pictures of Well, first of all, how many pages is it? Can you tell me that?
6.
And these are pictures, again, of people at the Alcium's property that were not the Alcium's. Is that accurate?
Yes.
Okay. And actually, they're not people, but they're vehicles that you took pictures of?
Yes.
Okay. And appears that some of the license plates are from Illinois. You heard Mr. Bennett testify that he's from Illinois. Was this the weekend of Mr. Bennett's group being at the property?
I believe so, yes.
Your Honor, we have for Exhibit 8.
Olsium's
No objection.
received.
I'm showing you it's been marked as Exhibit 9. Do you recognize this
Yes.
set of pictures?
Yes.
Okay, and it appears to be 3 pages.
Yes.
Again, pictures of vehicles on Mr. Alcium's property when people were there that were not the Alciums. Is that accurate?
Yes.
Okay, and do you recall what time frame this exhibit was on?
I'm sorry, I don't remember exactly which weekend this was.
Fair. If your affidavit said that these pictures were taken during the week of August 8th through the 15th, would your affidavit be accurate?
Yes, I took these pictures with my phone, so they would have had dates on the pictures.
Okay, and the information you provided for your affidavit would have come from that?
Yes.
Okay, so you think this was probably the week of August 8th through the 15th?
Yes.
Okay, Your Honor, we offer, I don't know if I offered Exhibit 8, but I offer Exhibit 8 and 9.
Mr. Olson's 8 was received.
Okay, thank you.
No objection.
Received.
Mr. Alcium, or I'm sorry, Mr. Brimacombe, showing you what's been marked as Exhibit 10. Do you recognize that document?
Yes.
Again, pictures of individuals, or I'm sorry, of vehicles at the property that you took in the summer of 2025. Is that accurate?
Yes.
Okay. And do you recall which time frame this was from?
I'm sorry, I don't.
Okay. Again, if your affidavit said that it was over the Labor Day weekend that this picture was taken, would you believe that to be true?
Yes, as I took the picture with my phone, which would add the dates, yes.
Okay. Your Honor, we offer Exhibit 10.
No objection.
Received.
Mr. Brimacombe, I've handed you Exhibit 11. Again, pictures of vehicles on the Alcium's property. Is that true?
Yes.
Okay. And there appear to be recreational vehicles, trailers, ATVs, things like that. Do you see that? Consistent with what Debbie Tate testified they brought up to the property?
Yes.
Okay. And do you believe that this to be the weekend of Memorial Day 2025?
Yes.
Your Honor, we'll offer Exhibit 11.
Mr. Olson's
No objection.
received.
No further questions.
Mr. Olson, questions?
Mr. Brimacombe, did you ever witness or see a rental agreement during the summer?
No.
Did you ever witness somebody giving me money for a rental?
No.
No further questions.
Any redirect?
No, Your Honor,
You are released. Thank you. Next witness.
that's all I have.
No more witnesses.
No more witnesses.
Mr. Olsiams, this is your time and your time to give me all the information that you wish to give me, all the testimony you wish to give me as it relates to Mr. Brimacone and Mr. Anderson's motion.
Mhm.
You are under oath. You may begin.
I have a quick question. My exhibit 1 is the same as their exhibit 4. So I don't know if I need to,
You do not need to use that. You can go off of exhibit 4.
okay. Can I bring exhibit 4 with me to the box?
Yes.
Your Honor, do we want him to have the written or the marked exhibit 4, or does it matter to the court?
He has your marked exhibit 4.
Yeah, I meant the one that the witnesses use. Okay, either way.
Totally fine.
All right.
All right. Mr. Olsiams, you may begin.
Well, very briefly, Your Honor, the order that you wrote does not say that requires a license from the county.
Let me read what my order says.
Okay.
Words are words, and I used words. My order said, the court finds that the plaintiffs have met the burden of proof and that there is no genuine issue as to a material fact. The facts asserted by plaintiffs are not refuted by fact or evidence and are so clear and convincing to the trier of fact that there is nothing left to establish. As such, the court hereby issues a permanent injunction, that's in all caps and bold, until such time Mr. and Mrs. Olsiams comply with and receive the state DATCP rental license and the Burnett County rental permit, and continues to do so annually as required, and until such a time that the above depicted nuisances can be abated. That's what the court said.
Well, my understanding of the order in conjunction with the county ordinance says that 10 days that I can rent the property for 10 days or less without any kind of county permission, license, anything. That's what the county ordinance says, and I believe that's what the right to rent state law makes a reference to that as well. So under that understanding, again, your order has to be in conjunction with the ordinance. So,
No, it doesn't.
well, if the ordinance says something, you can't change the law.
That can be your argument. I will tell you what I can
Okay.
do as a judge when I'm going to make my decision. I will stop.
Right. Well, the ordinance says that I can rent for 10 days and not have to get any licenses, permission. nothing.
Your Honor,
So
you've made the comment already about argument. I was going to do that earlier, and there hasn't been any actual testimony so far. This needs to be factual. The argument can be made from there or in
I'm just laying
writing.
a foundation for my state of mind.
All right. Well, I don't need a foundation for your state of mind. I understand you've heard my order, the words that were in the order. And I heard that you believe that the ordinance states you can rent for 10 nights or less without needing to get the permit. Okay.
Right. So I went ahead and rented my property for 10 days for this past summer, 2025.
All right. So I'm hearing right now, I just have to make sure you are admitting and stating on the record, you rented it for 10 days.
Correct.
All right.
And with, I'm looking at exhibit 4. What I did is I said that 2 days of the 7 were paid and the other 5 were complimentary to kind of save 5 of the 10 days. So of this, for Mr. Bennett, I'm counting 2 of the 10 for that purpose.
Okay. Got it.
And that's what shown here on the rental agreement.
All right, so then go forward and tell me, continue to go down, tell me the days that you rented, to whom you rented it to, and we'll go from there.
I don't remember. I just specifically remember it was 10 days when you include the 2 days, the Memorial Day weekend, the Labor Day weekend. So that would be 2, 2, and Mr. Bennett is 2, that would be 6. And I think there was another rental in there. I just remember that I wanted to keep the limit at 10.
All right, and so with the Memorial Day rental, with the Labor Day rental, with Mr. Bennett, it was, you rented it per your contract or how you had written the contract, 2 days for each.
Right.
So a total of 6. So where's the other 4?
Well, we got the Labor Day, right? Did we
I already
include
did 2, 2, 2. So that's 6. So there's another 4.
Let's see, that would,
Because we have the May, we have the September, and we have the July with Mr. Bennett. So
I guess what I'm saying, I kept within the 10 days. I don't remember exactly the 10 days specifically, but that was my goal or my intention, is just to stay within that 10-day limit.
okay. All right, what else do you want me to know?
I think that's it. That's pretty basic. That's, I admit to the renting. My understanding though, it's 10 days or less. That's what the county ordinance is. That's what the state law says in the right to rental.
Okay, and so nothing else you want me to know? And what about the money issue? You wanted to argue about the money issue. Tell me about that, or not argue, tell me about that in your words, because you were saying you were trying to have other witnesses tell me about money.
Well, just that he's trying to argue us, if he tries to argue a sanction that I was paid $5,000, that wasn't, that all didn't come to me. There were tons of VRBO fees and taxes and things like that.
Okay.
That's just the point I was making there.
Understood. So you didn't receive all the fees. Some of the fees went to VRBO and some went to taxes.
Right.
Excellent. Okay. Anything else?
That's it.
Mr. Anderson?
Mr. Olson, to be clear then, you did not receive permission from Burnett County to rent your property in Burnett County, true?
I never asked them for permission.
Fair enough. Then you never received a license from the state to rent your property in Burnett County, true?
No, because my understanding is I didn't need a license for 10 days or less.
Okay, so no, you didn't.
No.
No further questions.
All right. You may be seated.
Okay.
Okay, now, argument.
Your Honor, so a couple of things. I don't think well, first of all, Mr. Alsims has admitted to renting the property in Burnett County, in my opinion, in violation of the court order. We heard testimony from Debbie Tate that they brought multiple trailers, multiple ATVs, multiple vehicles. They had 12 people there one night, 10 people there another night. We heard testimony from Mr. Bennett that there were double-digit people on the property. There were multiple vehicles on the property again. This is sort of that nuisance. It's not sort of, this is part of the nuisance that has been part of the problem. There's been more than that, but that's been part of the problem and part of the issue of how many people are renting the property and staying there when this is not a commercial property. We've also heard testimony from Ms. Tate that she was there for 2 nights, 3 days. We heard testimony actually from Mr. Alsims that, and well, I'm sorry, not from Mr. Alsims. We have exhibit 1 that shows that the group that was there in August. I'm sorry, August 28th through September 1st was there for 4 nights. It says $995 times 4 nights. We have testimony from Mr. Bennett that they were there for 7 nights and 8 days. And they booked their vacation, I think he said 7 or 8 months prior to the vacation actually occurring. And then we have a rental agreement sent to Mr. Bennett at 5 p.m. the day before they are supposed to go to the property that owned by Mr. Alsiums for their 8-day family vacation. And obviously they signed it and moved on, and then they looked at it later and saw that there was this clause in there about complimentary days. That is a sneaky way of trying to get under the 10 days, which I don't think applies anyway in this case. But even if it does, Your Honor, the point of it is they were at the property for 7 nights and 8 days. The people from August 28th to September 1st were there for 5 days and 4 nights. We're already at 11 nights between those two. And then we have Debbie Tate, who was there for 2 nights and 3 days. Now we're at 13 nights and more days. And then not even to mention the other 2 groups that were renting, one from August 8th through August 15th, which again is another 8 days and 7 nights. And the last group being June 6th through the 8th. That was the one with the ambulance. There's less information about that, frankly, but there was extenuating circumstances there. But point being, Your Honor, there were renters there in far greater numbers than 10 nights. And again, I don't think that applies, but since Mr. Alsium's arguing it, I feel like I should respond to that because we are at 13 nights just for the 3 groups that have been proven here today in court without even considering the additional 2 groups. So any way you slice it, Your Honor, whether it's by what I consider the letter of the law in terms of he's not supposed to rent, period, without a license or permission from Burnett County. But even if we do have if that is the law, which I don't believe it is, he's still in violation of it. So frankly, a lot of the argument from Mr. Alsiums doesn't matter because he's in violation either way. If you want me to address sanctions, I can do that. I can do that later. I would ask for attorney's fees, Your Honor. And I didn't know how long today was going to go, so I'd ask for a little bit of time to submit that. So I can't do that today because I didn't know how long it was going to be.
All right. So yes, argue sanctions, and then he will have the opportunity to refute all that you've argued.
All right. Your Honor, I think sanctions are appropriate here. He's already been found in contempt of court for this very same action in the past. The court sanctioned him then. I think the court should sanction similarly. I think Mr. Alsium is right. He predicted that well because I think I did it last time. But the fees that were paid, I can do the math, but there's the $3,980 that was paid for the 4 nights in September. And then Mr. Alsium talks about service fees and tax. Well, that's fine, but the cleaning fee went to Mr. Alsium's, and so did the $3,980 for that one. We can look at the one for Ms. Tate. She paid $1,990. Then she has host fees, which again would be to Mr. Alsium's service fee and tax. We can take that off. Those numbers again are fairly clear, so that's $2,380. Your Honor, we also have Mr. Bennett, and his was $5,665, which was the per night of $809.29 times 7 nights. That's on Exhibit 3. There's a cleaning fee that went to Mr. Alsium's service fee and tax. We can take those off, and that's fine. But I think that the profits and the money that was received by Mr. Alsium's are ill-gotten gains in a case like this, and those should be forfeited by him as a sanction. And then I defer to the court on additional sanctions. There was in the prior contempt order, Your Honor, there were purge conditions. Obviously, those purge conditions did not happen, and now we're here on round 2. And I don't normally expect to see round twos on things like this, but here we are. And that's why I'm asking for sanctions as they are and attorney's fees. But again, I'd like, give me a week or two to get that to the court.
Right, and so your argument is you were arguing for sanctions. Your argument is, if I'm hearing correctly, that you are making an argument and a statement that purge conditions were ordered by the court to Mr. Olseams, and pursuant to the court's order, Mr. Olseams did not comply with the purge conditions. So that's one of the arguments. The second argument is you're arguing for attorney's fees to have to come to court for today and all of the related expenses to today's hearing. Plus, you are arguing to the court that a sanction for Mr. Olseams should be forfeiting all of the funds that he did receive and profit from the rentals that you had proof of.
That is a good summary.
Excellent. Thank you. Mr. Olseams.
Again, Your Honor, my understanding was 10 days. That was my intention. I don't think Mr. Anderson's math quite adds up, but they've only presented Mr. Bennett and Ms. Tate. That's 2 days and 2 days. That's 4. Again, it was my intention to stay under the 10-day limit. And I think even you made a reference yourself at the beginning of the hearing that it has to be within the ordinance. The ordinance is 10 days.
I said that was your argument.
Right, but that's what my understanding was, is that that's any person in the county would get 10 days. I don't see why I would be any different than that.
Okay. Any response to the other arguments that Mr. Anderson made, especially as it relates to any types of sanctions?
Again, I believe I complied with the order, so I don't think any sanctions are appropriate. It was my intention to comply with the order until all of this is finally adjudicated. So.
All right, so Mr. Olseams, I do have a question for you as it relates to this matter, and it's a hypothetical. I just want to have an understanding of where you're coming from and what your thought process is as it relates to not only the Burnett County ordinance in the state as it relates to the 10-night limit, but also as it relates to you and your givings, I guess, your generosity, I guess, as it relates to the renters. That's the argument I'm hearing from you.
Wait, you mean the free days, you mean?
Yes. And what was your purpose of the free days to individuals, other than staying within that 10-night limit?
That's the only reason.
That's the only reason?
Yeah.
No, again, grandiose generosity, those types of things. It's just so you can stay within the limit?
Well, sometimes somebody will ask for an extra day, and because I can't rent it continuously, I would have, say somebody was there for a couple of days, there's nobody there after that. Somebody might say, can I stay a few extra days? Because I had a wedding, or I'll let them do that.
Free of charge?
Free of charge, yeah.
Didn't your last renter from our last hearing and last contempt order, she wanted to stay there for additional days? There was something, she was staying there for a wedding, but then she had to pay extra money?
No, exact opposite. She wanted to stay longer and I didn't charge her for it.
You can refresh my recollection with the transcript, and I could do that. I just want to have an understanding. So I also want to have an understanding. I just want to wrap my head around this. So you wanted to stay within the 10-night limit, correct?
Right.
And you have testified to court and you admit that you stayed, you rented 10 nights, 10 days only, correct?
10 days or less, yes.
Or less. So you've rented the limit of 10.
Right.
All right, 10 days, 10 nights, 10 days.
10 nights is kind of like because again, somebody, if they just stayed a night, they would come the first day, stay the night, and leave the next day, that's technically 2 days, but it's one physical day. That's why it's by the night.
Okay, and so I can have an understanding that you did state and you admitted that you rented for Memorial Day weekend 2 nights, for Labor Day 2 nights, and for Mr. Bennett, he stayed 7 nights, but you only charged him for 2.
Right.
And with regards to the amount, I think was like 6,000 something, almost $6,800, $6,840 if I'm going off my recollection, but I don't have it, can't find it exactly in front of me at this time.
Which one are you,
I'm sorry, it was it the $5,151?
which one are you looking for, Your Honor? I
No,
can
I'm
help
looking
maybe.
for Mr. Bennett's.
Exhibit 3, I
Oh,
believe.
Thank you. Yes, it was 6,000. The $6,980.48. All right. So Mr. Bennett, he stayed 7 nights, but you only charged him for 2 nights.
Right.
And so the 2 nights that you charged him for cost $6,980.48.
Right.
Okay. But then you're like, yeah, 2 nights, but I'm going to give you 5 for free.
Right.
And then you had, so that's 6. And then, so there were other rentals that were discussed earlier. We don't have any exhibits or proof or evidence from Mr. Anderson or Mr. Brimacone, but you are admitting then you did rent to other individuals for at least 4 days.
I just recollect that I wanted to stay within the 10 days. I don't remember exactly how that all played out. I just wanted to stay under the 10 days.
All right, so in those rentals, and you don't recall, and I don't need specific details, I just want to have an idea. In those rentals to individuals, was it more than 1?
I don't recall. I think it was maybe 1 or so. I don't remember.
It could have been 1, it could have been 1, could have been 2, or are you pretty sure it was 1?
I don't recall exactly. I just know it was 10 days. I wanted to stay under the 10 days.
Okay,
the 10
and
nights.
I get that, and I understand your argument.
But I don't recall exactly which.
Recall exactly if it was 1 or 2. Let's say it was 1. Do you remember if that person, that individual, were you nice to them too, and did you give them some free days?
No, it was only for the 7-day stays.
Okay, all right. So they didn't stay 7 days?
No.
Or was it going to be a 7-day with that person and you only had them pay for 4, but then you gave them additional 3?
I don't recall. I just recall that it was like a 2-day type of a thing.
What do you mean it was a 2-day type of a thing?
Well, I only do the complimentary days on someone that wants to stay 7 days. Anything that's less than that. So I'm kind of adding everything up. Well, this is 2, and 2 here, as long as I stay under the 10.
Do you remember in this past year, since my order and your understanding of the order, other than Mr. Bennett, did you give anyone some free days?
I don't recall.
And you've been in front of this court before and you are meticulous at keeping records, is that correct?
Not really. Again, I just generally know that I have to stay under the 10.
Okay, and I understand that. But in our other cases, it's my understanding and my interpretation of how these cases went. Would you say that you did have all of the documentation in the other hearings?
I actually didn't. I think Mr. Anderson is one that had all the documentation.
Not in the contempt hearing. Let's go to the other hearings.
Yeah, even the other hearings. It was Mr. Anderson that had all the documents.
Oh, so Mr. Anderson is better at keeping your records than you are?
For the most part, yeah. Because he's trying to prove rentals.
Oh, good job for keeping his business records, Mr. Anderson. Okay. And so then how do you pay your taxes, Mr. Olseums? Because you need to keep business records. You need to know how much money is coming in, and you need to be able to report that to the state, as well as the state of Wisconsin, as well as to the federal government.
Well, there's a federal law called the Augusta Law, which came from homeowners that were renting their properties for the Masters. And they were renting them just for the tournament. And out of that came a federal law that says if you rent your property for 14 days or less, you don't have to declare the income.
Okay, all right.
It's called the Augusta law.
And so does that include all of your rentals or just your rentals in Wisconsin and then separately from?
Per property. Yeah.
Okay.
So it's just kind of well, I know I have to stay under the 10. I don't have to do meticulous record keeping because it's under the 14 for taxes. So I just know it's 10 days or less. So it's kind of an informal, lackadaisical. I think the reasoning there is the difference between a serious business and just kind of informally renting your property, which is what the people did at the Masters. They're just getting some side income.
All right. Well, then I have to talk to my accountant.
It's actually a great law. And when you think about it, it's kind of you don't get to write everything off though. You get to not declare the income, but then you don't get the write-offs.
Okay.
So it's kind of the line between a serious renting business and, you know, it's your property that you live in that you're just occasionally renting.
And what year did that happen?
Probably 30 years ago.
30. Why?
It's been around a long time.
I was in the rental business, not before I was a judge. And I did short-term rentals and things like that. My accountant never told me that. I'm going to go back and get my money back.
Did you do more than 14 days
No, I did not. I stayed within the 10-night limit.
here in Burnett County?
Yep.
Yeah, well, it's a nice law, actually. Again, it's called the Augusta law, 14-day.
I'm going to look at that, and I had other property too in other places, but my accountant is going to hear from me for sure.
So just in general, for the last couple of years, until this whole thing is adjudicated, I've moved it from a serious rental business to lackadaisical, 10 days or less.
You're there renting some, but giving 3 days.
Right. Just to kind of like say somebody wants to stay 7 days and I'll try to stay within that 10-day. Well, you know, here's some free days kind of thing, which I did for Mr. Bennett.
All right. Okay. All right. 3 days. Okay. Now, Mr. Olsiums, I'm going to turn to you for your motion. I need to pull that up though, your motion to stay. And Mr. Anderson, you had that too, correct? You understood you filed one?
Yeah,
A long time ago.
it was, I didn't recall it, but yes, I do now.
So I'm just going to give him the opportunity. It wasn't specifically noticed or request to have a hearing, but I'm going to give him the opportunity right now. We're all here. And just so he can argue that. And it was filed on November 3rd, 2025. I'm pulling that up right now. Okay, Mr. Olsiums.
Well, just as we know, this is, I've asked the Court of Appeals to adjudicate. There are numerous from A to Z in this case. Whether or not this could even be a nuisance to the, you know, there's probably, I've identified 6 or 7 major legal concepts that I'm going to ask the Court of Appeals to address.
6 or 7? Okay.
I mean, when you think about it, you know, from the nuisance, you know, to the injunction itself, to all my claims being dismissed, there's really a whole litany of stuff. And I think it, just to make it, you know, fair and kind of make sense, I actually think that this is going to set precedents at the state level for, you know, can something like this even be a nuisance? Right. And I think that, you know, it needs to be decided at a state level, that there's a lot of short-term, you know, renters, property owners in Wisconsin that want to.
You can understand that it could make case law. It can't make statutory law. That's something that the legislature would have to do, and the legislature would have to change.
Right.
All the Court of Appeals would be doing would be looking at my decision, the facts of the case, and seeing that I stayed within my parameters and I didn't, you know, do anything gross.
But I think the issue that it comes down to is nuisance. It's really the garbage can law of really not just Wisconsin, but any state. I think Mr. Anderson and the plaintiffs were desperate to, if you understand This is like an island. It's not like a city block.
Find it, it's not an island. It's a
Well, it's like
peninsula.
peninsula, but the point I'm trying to make is that, they've been out there for 30 years. I've been out there for 30 years. Everybody looks at it like their backyard. So when strangers come up the road and you come onto the peninsula, it's kind of like somebody coming in your backyard. You're like, oh, I don't like that. But we have a right to rent our property, and, getting into whether it's 10 days or does the rental, another thing, I think it further clarifies the right to rent law that Scott Walker passed in 2017. I think the purpose of that law to begin with was to, stop. It was to enforce the right of a property owner that they have a short-term rental right. So I think when you understand this island, it's not like a regular, certainly not a city lot. It's like where you have a block and there's house. And it's not even, I don't even think it's a regular lake lot, because if you think of a regular lake like Devil's Lake, a circular lake just with property next to it, this is a peninsula. So there's only 4 owners out there. So they all look at it like, hey, this is like our backyard. So when strangers come up the road, they're kind of like, how would you feel about somebody coming in your backyard? So I think they went to Mr. Anderson and, hey, we, find some legal theory to stop this. And, nuisance is kind of like the garbage can. And again, I my research on nuisance law, again, you can't just say, like, for example, I don't like somebody mowing their lawn. I don't like the noise and it bothers me. And I'm going to say it's a nuisance that somebody is mowing their lawn. Well, it can't be a nuisance because they have a legal right to do that. It's like, if I don't like somebody driving down the road, I don't like the sound of their car. It's a nuisance. I feel that's a nuisance. Well, it's not, because we all have a right to use the road. So similarly here, because it's a peninsula, because everybody's been there 30 years, they kind of look at it like their backyard. They try to find something, and garbage. That's why they call it the garbage can of law. Nuisance. If there's not a specific law, or there's maybe other exact law going against us, let's claim it's a nuisance. So if you recall Mr. Brimacombe's testimony, he didn't really say he had any, there were no police called, there were no loud parties. They tried to say that the septic system smelly, and if you recall the damages hearing, I showed that, Mr. Brimacombe claimed that there was like 16 cars. It wasn't even possible to have 16 cars there. So they just, are using this nuisance law to try to claim, which is again the basis for this injunction, for this renting, which I think is a major linchpin in this entire case, right? If it's not a nuisance to rent your property, then everything else falls apart. So that's why I think the make sense thing to do is, let's let the Court of Appeals kind of hammer out these, because again, this is, I feel it's probably going to be a set precedent for the state.
How so?
Again, if I have a legal right to rent my property, how can that even possibly be a nuisance? If it's like I have a legal right to use the road in front of me, I have a noisy car, is it a nuisance to run my car up and down the road?
You're getting really, really far off of the facts or where we are.
Well, just the concept is nuisance. Is it a nuisance to rent your property? I mean, they tried to show the smelly septic because they tried to show that they try to get away from the actual point of renting your property can't be a nuisance. They were trying to say, well, it's a smelly septic because they have 14 people renting. And that's why the smelly septic is because there's 14 people renting the property. And
Mr. Alsiams, I'm going to stop you right there, because if you were to have properly followed the law and you were to have gotten your tourism license and the Burnett County license for the short-term rental, it would your septic would need to be looked at, and you would be told the exact amount of people you could have in that property based upon that square footage and the septic that was installed, if you would have done what you were required and legally required to do.
But if I could make a comment on that, I'm actually a construction person. I've actually installed septic systems.
I know you,
and the
you
point,
said that in the last hearing, and I heard that.
and the point is, you know, the usage and flow on that, it's continuous flow. So even if, for example, if I have a party at my house and there's 20 people there for a weekend, that's not going to overrun the septic system. You have to have week after week of 30 people. You know, that's just not happening here.
Okay.
And so they're trying to argue smelly septic because there's more than, you know, again, just the desperation to try to, you know, climb in the
nuisances.
right. But again, that was refuted because there was no inspection done. There was no professional that came out and said, yeah, it's malfunctioning because there were 14 people here that weekend. I mean, it takes week after week, month after month of over.
Right.
So again, so I think why a stay would be appropriate is that, you know, it's not, you know, just the nuisance part, which again, if that goes, you know, everything pretty much falls apart. If, you know, my claims, again, there was general disputed material fact. They basically got up and just with an affidavit said, I'm claiming this. And I got my affidavit in the same day of the hearing when we had that. So we have disputed fact there. And all my claims were dismissed because,
Okay.
so again, there's a lot of things going on. I think
what
that
is your legal basis? Do you have any case law? Do you have statutory law? Do you have something for me to hear or to understand? But what is your legal basis for requesting a stay?
the legal basis is that
That means case law, that means statutory law. What is that basis?
well, I think, well, statutory, as I mentioned, nuisance. Can this be a nuisance? This is a primary fundamental right of any property owner in Wisconsin. I've suffered, you know, lost rental income for the last couple of years because of this. I certainly this is a major harm to me by.
Right. Yeah. Okay,
So, so until I just think it makes sense that, you know, structurally in case with the law that, you know, this isn't a garden variety claim damages. There's a lot of legal merits here that I think need to be determined statewide. And it makes sense just to put everything on hold until the appeals court rules.
Okay. So I understand that now. Now, with regards to the court's October 4th, 2024 order, I have your understanding of that order. You filed a motion to stay. The court did not hear your motion to stay, and I could have ruled on it at that very moment. I did not.
I'm sorry, 2025, you mean? Or
25, I mean, yeah. October 4th, 2025, sorry. And in that order.
It's actually 24.
It is 24. It is 24. See, I was correct. October 4th, 2024, right?
There's another one that looks like it's September 5th of 2025. That was, I believe, the contempt part, but the original one is the October of 24.
Oh, yes. Okay. So thank you. This has been a long process. Thank you. Because that the important thing here and what the court has to do is take it by stages, because the court first ordered October 4th, 2024. And I read to you what the order was from the court that you must comply with. And I'll state again, the court hereby issues permanent injunction until such time that Mr. and Mrs. Olsiums complies with and receives the state DATCP rental license and the Burnett County rental permit, and continues to do so annually as required until such a time that the above depicted nuisances can be abated. That's the October 4th, 2024. Then the court had another order that the court entered on August 28th, 2025. from August 28th, 2025, the court had certain orders and found that you had certain compensatory and punitive damages for nuisance, for civil trespass, and for property. The court also found you in contempt of the court's October 4th, 2024, and had certain sanctions that were applicable at that date and time, and gave you purge. Do you understand what purge is? Gave you the ability to purge that, and to, as long as you complied with certain things, the jail, it says the things may be purged following full compliance of the October 4th, 2024 order, or 2024 court injunctive order, and full payment of the court sanctions, fines, and fees within 60 days. All right, so that was the court's August 28th of 2025 decision. And so with regards to the August decision, Mr. Olsiums, did you comply with that order?
I guess I don't,
Did you comply with that order with paying the court fine of $2,500 for each violation?
I didn't pay the fine, no.
You didn't pay the fine?
No.
Because I think if I calculate it correctly, I think the fine would have been due and owing October 26, 2025. So by October 26, 2025, you did not pay that court ordered sanction of the $2,500 for each of the violations?
I guess I didn't see that in the order.
But you did receive a copy of the order, correct?
Yes,
And you are an e-filer too, correct?
yes.
And so you did receive that order from the court, which does have that sanction, as well as it says court fine $2,500 for each violation, totaling $5,000, a 45-day jail sentence for each violation to be served consecutively for 90 days of jail. And it says that the jail sentence may be purged, and that means you won't have to sit the jail if you do these following things: full compliance with the October 4, 2024 court injunctive order, and full payment of the court sanctions, fines, and fees within 60 days. I get your argument as to you believe that you're in full compliance. You believe you complied with my order, but so you didn't pay those fines and fees by October 7th within 60 days from the court's order.
I don't think I even have that money to pay.
Oh, so, okay, but you got the order and you understood the court's order as well as the purge, correct?
Yes.
Okay, now, with regards to that, I've heard your argument for stay. I've heard those things. Mr. Anderson.
Your Honor, there's a lot of argument about the facts of what happened and sort of a rehashing of that. And I don't think that's anywhere near the standard for a stay. My understanding, and I don't have any case law or statutory citations to point the court to as I sit here right now. If I go back to my office, I can find some, but part of it, I believe, in arguing these before is
Sorry, I'm sorry to interrupt. I wanted to then say that his stay, my decisions were October 4th, 2024.
Yeah.
August 8th, 2025. And then the court received a motion to stay on November 3rd, 2025. I just wanted to state those dates on the record.
And just to be clear, it's August. It looks like it was date signed August 29th.
Oh, 29th. Yes.
Yeah, just making sure.
Oh, sorry. Let me repeat that. The first order, October 4th, 2024.
Yeah.
The second order, August 29th, 2025. Mr. Olsium's motion for the court to stay all orders pending appeal filed November 3rd, 2025. Would you agree with that, Mr. Olsiums?
Yeah, apparently, yeah.
Yeah, okay. Mr. Anderson. Sorry to the dates.
No, that's okay. I'm trying to think about the timeline for that too, Your Honor. But I think part of that is a likelihood of success on appeal. And I think that's a huge factor that should not be overlooked. The argument, Your Honor, touched on something I was thinking when Mr. Olsiums was making his argument, is that the Burnett County ordinance, with the 10 days and the requirement for the license at DATCP and the permission from Burnett County back in 21, 22, 23, 2024, all the way back, was never complied with. That's clear in the record from the prior hearings. It's clear again today when when Mr. Alsiums testified that he didn't go get permission for Burnett County, did not get the license from DATCP. That in and of itself had he done that, would have allowed what Your Honor already said about the county and the state putting some requirements on there, but it also would have allowed, I think, based on the Burnett County ordinance, it would have allowed the neighbors to have input as to what their concerns might have been, which may or may not have, but at least they would have had the input. It may or may not have had an effect on what those requirements might have been from the county as to what Mr. Alsiums was required to do in order to allow him to rent the property. This is a residential area. This is not a commercial area, but Mr. Alsiums treated it as a commercial area. And so likelihood of success on the merits, Your Honor, being a factor, as I understand it, that's just not there. The arguments are akin to what he's making today on the contempt piece, Your Honor. Exhibit 1 says 4 nights. Mr. Alsiums was the one that exhibit went through and through him. Exhibit 3, it says 7 nights. And if Mr. Alsiums, it's a strained argument at best that he rented his property for $7,000 to Mr. Bennett for 2 nights and then just gave him the other 5 nights for free. It doesn't pass the smell test whatsoever. And then exhibit 6, Your Honor, shows another 2 nights. So again, just the exhibits that have been presented to the court for those 3 stays in 2025 show 13 nights. His argument about the nuisance is almost as strained as the argument about his rental activity in the summer of 2025. He has, in my opinion, very little chance of success at the Court of Appeals on this case. A lot of it was, it was based on this court's review of the record, late submissions by Mr. Alsiums, no issues of material fact, and ultimately, as Mr. Alsiums has continued to prove, he doesn't care what the law is or what the court orders. He just does whatever he wants. And so with all of that as a backdrop, Your Honor, the stay should not be imposed. Who knows what will happen to the property or any assets that Mr. Alsiums might have if a stay is imposed and he's allowed to be free to dispose or dissipate his assets, whatever the case may be. I think the lien needs to stay on the property. I think if my clients decide that they want to file a foreign judgment over Minnesota where Mr. Alsiums lives, they should be free to do that to secure their rights in the assets that would be able to pay the judgment. Additionally, excuse me, Your Honor, I lost my train of thought. I apologize. Oh, in the event that my clients do a levy of execution or something like that, garnishment, etc., and the Court of Appeals comes back and says no, or somehow for some reason grants Mr. Alsiums' appeal in some fashion, well, then my clients would be on the hook to repay that. It's no different than the situation we're in right now. And so I don't think that there's any reason to stay the court's judgment, given the behavior of Mr. Alsiums, given his propensity to ignore the law and do whatever he wants. I think for the protection of my clients, Your Honor, the stay should not be imposed.
All right, thank you. You get a brief rebuttal.
Just that I've acknowledged the 10-day rule until this is all adjudicated, and I've adhered to that, and I have not done what I wanted, restricted my rental until this is all adjudicated.
Okay, and there was another issue that had come up, and I just need to make sure that everything's taken care of, because you filed an appeal and you needed a transcript, and there was some kind of conflict that was going on with regards to payment of that transcript? Was that transcript paid for?
Yes, that's all been taken care of,
Okay, how was it paid for?
through, Venmo.
Through Venmo?
Yeah.
Okay, and so when was it paid through Venmo?
She,
She can't testify, so do you have an idea? Because
A month
my
ago?
order went out on January 6th, 2026.
it was before your order, before the 15th. I think it was the 10th, maybe, or the
That's not
6th.
what I recall, because otherwise I wouldn't have done the order
I know I did,
after that,
I did the payment the day of the order.
the day of the order.
Yeah.
Okay, so you paid for the transcript by Venmo the day after you received my order.
No, the day of your order, I think it was the day of your order, the same day.
Same day of my order. So my
Yeah.
order went out January 6th right away in the morning, and then you paid for the transcript by Venmo later that day?
I think your order went out in the afternoon and I had paid, I think, just before your order,
I mean,
actually.
that's easy to check, Mr. Elsiams.
I'm sure.
I can definitely get that and get it all verified. But that's not my understanding. It wasn't paid for. Otherwise, I would not have done an order. And so my order did say pay for the transcript. This is all bold and capital. Payment for the transcripts be made on or before January 15th, 2026. And yada, yada, yada. Then again, and all bold and capital, payment shall be made by cash underlined or money order underlined, payable directly to the court reporter. And you paid by Venmo?
Well, we had been discussing payment for a month and she said that she accepted Venmo, but would be a fine payment. So that the day of your order, that's when I paid via Venmo because I established a Venmo account and I paid her via Venmo the same day of your order.
All right, so you paid the same day, all right, of my
Yeah.
order. So you didn't do what you wanted to do and paid by Venmo, even though the court ordered you specifically to pay cash or money order because of the difficulty that arose between payment, correct? Correct,
Her and
yes or
I-
no? Yes or no?
No, we were speaking for a couple months and she said that Venmo was
I'm
acceptable
not gonna
payment.
have her in the middle of it. I just know my order went out on January 6th. You paid January 6th by Venmo.
Right, yes.
Right, okay, all right. So with regards to the motion to stay, there are things that the court has to follow. There are, and State v. Guddenschwager, 191 Wisconsin 2nd, and it's GUDENSCHWAGER, 1995. It says the court must look at 4 specific things. 1, the likelihood of success on the merit, irreparable harm to the other parties, and the public interest. All right, and I've heard the arguments of the parties, and I understand, Mr. Olsums, you believe that this is going to create new law and precedent, and the Court of Appeals will make everything right and will define nuisance and will overturn this court's decision and the orders that I have, not just 1, but 2. I have two orders in this case, 2 separate orders in this case. Court here, I don't find that you have shown that or demonstrated a strong probability on appeal that it will be successful. The court thoroughly went over what nuisance was. The court thoroughly went over the violations that were occurring while you were renting your property out to other people. Very, very clearly in my first decision, because my first decision, it's 26 pages long. Granted, it's not all 26 pages. It's 15 pages of the court analyzing the law, interpreting the law, and analyzing the facts of the case, and then putting it on a decision in order. The other pages from page 16 to 26, those 10 pages, they were here to help you out. A guide to renting out your property for overnight stays. Protect yourself by knowing Wisconsin's law for short-term rentals. I gave you that pamphlet, so it would explain the law, explain what you need to do. So that was there. The second thing was the Department of Agriculture, Trade and Consumer Protection, the tourist rooming houses, and what you must do to follow that law for the DATCP. Then the court also provided you with the permit application for the tourist rooming house. So you could have that along with another brochure, the Wisconsin Short-Term Rentals Law. and it has little arrows and things and little boxes, and it makes it really easy to follow to make sure that what you need to do to comply with that law. The court then also provided the short-term rental license application for Burnett County, clearly gave it to you, showed what you needed to do, had it right there. And I also provided the Burnett County licensing requirements right there, so you could have them right there with the additional provisions. And then I, beyond that, provided Burnett County Ordinance Section 30-455 short-term rental, which clearly goes over what a short-term rental is. And I went beyond that because there's issues and arguments with parking. I put in Burnett County Ordinance Section 30-480 parking as it relates to off-street parking. And here it would be with short-term rentals. Very clearly laid it out because you were very clearly violating the law. That was well proven, directly proven. I don't think it could have been proven any more clear to the court that you were violating Wisconsin state law and Burnett County ordinance. And the court did state that. And then the court did, that's why I entered the injunction with those requirements that you, again, I will read it to you, that what my order says, word for word, my order says, as such, the court hereby issues a permanent injunction until such time that Mr. and Mrs. Olsiums complies with and receives the state DATCP rental license and the Burnett County rental permit and continues to do so annually as required, and until such a time that the above depicted nuisances can be abated. So there's two things here. I hear your argument about nuisances. You want the Court of Appeal to look and see, wow, Judge Mogan doesn't understand what nuisance law is, and that's fine. But then there's that other first part that the court clearly says, permanent injunction, meaning not one, not two, not three, 0. No free days, no none days, no, I'm going to give it to you for 30 days, but I'm only going to charge you for 1 day. But don't worry, it's going to be $30,000 for that 1 day. But I'm only renting you for 1 night. Clearly says permanent injunction until such time that you and Mrs. Olsiums, that you comply with and receive the state DATCP rental license, that you do that, and the Burnett County rental permit, and you continue to do so annually. So you stay compliant. The order does not give you authority in any way, shape, or form, to rent at all, even with the Burnett County ordinance of, having, or the state, which says 10 nights or less, or 10 days or less. Nothing about that. And the court's order clearly defined all of that. I had all of that information in my order. So if I was going to give you authority to say, all right, you can rent it for 10 days or less. I mean, really, you can rent it for 20 days as long as you give them 10 for free. That's totally fine, but charge them for the 20, but you only rent them for 10. I said nothing about any ability to rent at all. It's a permanent injunction, permanent until you do those two things. All right. Until you do those two things. You did not do any of those things. Instead, you rented it. You were found in contempt. You had far more days for the rental at the last contempt hearing. So the court found you in contempt. And this hearing, or this case, you're like, I'm going to outwit the legislature. I'm going to outwit the Burnett County Board. I'm going to outwit Judge Mogan and Attorney Anderson. That's what you thought. You thought you're smarter than everyone else in the room. You are not smarter than anyone else in the room. I was number 2 out of 105 people in my law school graduating class, okay? I know how to analyze the law. You were trying to be sneaky and deceptive, and you were trying to get away with something that is clearly not legal or correct. You rented over the 10 days again, whether it's 11 days, whether it's 13 days, whether it's 14 days, you admit on the stand and at the table was 10 days. I rented 10 days, exactly what I'm said I could do in the ordinance. I did not do above. But I did give them 5 free days. Can't remember anything else, but I gave them 5 free days. So that's 15 days. 15 days you admit to. 15 days you admit to. I don't even have to go with any evidence or anything that's been filed or served by or received by the court from Mr. Anderson. You admit to 15 days. 10 you rented for money and 5 you gave for free. Even if I were, Mr. Olsiums, to take you and believe you, that is your understanding. And even if the court were to go, I don't think I wrote my order as clearly as I should, which I did though. Even if I took that and listened to your argument, you violated the ordinance. Free days count, Mr. Olsium. Free days are not free days, especially when you're charging $6,980.48 for 2 days. What fool's gonna pay like almost $3,500 a night? A fool would pay $3,500 a night. It's absurd. It's ridiculous. And I can't believe you think that a court would fall for it. The Court of Appeals will not fall for it. I'm telling you that. They're very smart. Probably smarter than I am. They do this all the time. They're not going to fall for your shenanigans. They're not going to. You're nodding your head up and down. I don't know what that means if you're saying yes or not, but that's where we are. You violated the order again. So I do find you in contempt for these violations. As to the sanctions and whether or not the court orders attorney's fees, etc., I am going to stay on the sanctions part of the decision because I don't have that information in front of me. And with the last contempt, I did deny attorney's fees for particular reasons, and I can't just go off of this is how much how many hours it is. There has to be the other arguments per the statute and the Supreme Court rule. But I do find you in contempt. Further, beyond that, you didn't follow my August 29th, 2025 order. Very, 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 very clear. $2,500 for each, capitalized each, violation, parentheses 2, totaling $5,000, plus a 45-day jail sentence for each, capitalize each, violation to be served consecutively. Serve 1, serve 2, for 90 days jail in parentheses. The jail sentence may be purged. You may get out of that completely. I don't have to do it. That's good. I don't want to go to jail. On the following conditions: full compliance with the October 4th, 2024 court injunctive order. One way that you can purge it, plus the second way, full payment of the court sanctions, fines, and fees within 60 days. Court calculated it. I did it twice. I did it 3 times actually. The deadline was October 27th, 2025. October 27th, 2025. Let's get to that. That was a Monday. You had until October 27th, 2025, Monday, to pay that, to purge your jail. You didn't do that. Moreover, even still, your motion that you filed to stay all orders pending appeal was filed on November 3rd, 2025, beyond the deadline that I gave you to purge. Beyond that, it's late. It doesn't count. You may want me to stay the other decisions, that maybe the other parts of it, I guess. I don't even know, because I'm going to tell you your motion, your petition here, it's hard to understand. Doesn't even make sense. And you're just spewing things that you think and you interpret as the law, or actually what you want the law to be and how you want it to be. So you can follow it and you can do what you want. So the motion to stay is denied. I don't find that you've met any of the factors that you need to meet. I don't think there's a high likelihood of success on the merits. I just went all over that. I don't think you're going to be irreparably harmed by if the court doesn't stay it, because it sounds like you're going to do what you want to do anyway, and you're going to try and do it and just hope you don't get caught. Harm to the other parties, harm to all of the other plaintiffs and all the other people here is higher than yours because you continue to do these things. Not only, we're not just talking about the sewer. That went away. That was the only time I heard about it. Then I heard about the damage to the trees. I heard about the urinating in front of their camera. I heard about all of those other things in which the court found you nuisances, you violated, you did things that interfere with their ability to enjoy their property. The public interest here, I have to weigh the public interest. And here the best interest of the public is not to stay. It's to continue to have these specific parameters in place that you must follow, because it's been shown that you do not follow. You don't follow the law. You don't follow what the legislature says. You don't follow what the law enforcement says. You don't follow what the court says. You don't follow what anyone says but you. So I'm denying your motion to stay. And I'm finding you in contempt of the court's contempt order. I'm imposing those sanctions. You failed to pay $5,000 by October 27th, 2025. That means that the jail sentence stays 90 days in custody immediately. As to the other parts of the order, the court will again stay on that and we'll get it out. So you'll be remanded to custody for your 90-day sentence. You failed to purge. You did what you want.
Your Honor, can I purge right now?
No, you didn't have the money. You literally just said on the stand. Stop.
I have a credit card.
Stop. You literally said on the stand or on your table under oath, but I don't have the money. I can go back on a transcript. I can go back. You said those words.
I don't have it. I have it on a credit card though.
That's money. You could have paid it on a credit card by October 27th, 2025. But if you read my order clearly, words are clear, by October 27th, 2025, then the jail goes away. It's February 6th, 2026. Far beyond that. The court's enforcing it. You're remanded to custody immediately, 90 days. Thank you. We're adjourned. Sometime you have to start abiding by the law and orders of the court, Mr. Olsiams.
Can I purge, Your Honor? I have a lot of business and things that I wouldn't.
Well, what you can do is you can pay it and then you can write a letter to the court and then I'll consider it. But right now my order is very clear, very clear. The purge condition was very clear. So if you would like to pay it and then you would like the court to, it's called reconsideration, you sure can do a motion to do that.
Can I do that right now?
No, you have to go up to jail.
How would I make?
Go up to jail.